have Ms. Baldwin, Ms. Turnbull. Do I have Lacey Klopp?
You have Mr. Roberts, who's new to the case.
And
Okay.
Your Honor, we sent an NOA in yesterday. It should be there any minute, but I'm appearing for Ms. Klopp, and I'm up to speed enough to discuss this hearing today. So we can go forward.
So we're here for the review for the guardian ad litem report. There was a little bit of additional information that we were waiting for, but we're just able to get that in within the last bit. But it's quite a bit of volume, so we were synthesizing it to be able to provide to the guardian ad litem. So I know that she was sort of waiting on that, given that the report's clearly not in the file. I think this should stay with Your Honor, and so I would ask that we just set to the next docket that Your Honor is available. And I think that's
August 20th.
That would be fine. And my client's not available through August 6th. So we would, the 13th or the 20th. And if the 20th is the first available, then that's fine.
Mr.
I'm available the 20th. What I was hoping to do, and I believe I spoke with Ms. Turnbull, and I believe she has some update, but I'll defer to her. This has been an ongoing situation with delays due to additional information that Ms. Baldwin's tried to get to Ms. Klopp. My understanding is that Ms. Turnbull, her inclination thus far has been to expand my client's time. This was on June 4th. We are now at July 23rd, and we are about to be at the end of summer without my client having any expanded time. The very least I'd ask for, I don't have an objection to the continuance because I know Ms. Turnbull needs to finish her report, but pursuant to Ms. Turnbull's input, I would ask that my client has expanded visitation between now and that hearing, because the delays are solely because of father doing this last minute fishing expedition, for lack of a better term. It may determine the outcome, but I doubt it. And at the very least, if Ms. Turnbull is on board with expanding some time, giving my client more than she currently has between now and the next hearing, that'd be great. I also understand that some of the outstanding information that Ms. Baldwin is trying to get to Ms. Turnbull is pursuant to at least one subpoena that was objected to, that was never calendared for the court to determine whether the subpoena should go forward or not. So I know that's not on the docket today, but I did want to raise that because it sounds like there's probably an issue there, but I can't speak more to it at this point.
So in regard to this idea of expanding or changing one, I have no report, and I get it. Ms. Turnbull is still working on it too. I have no written motion. I understand, Mr. Roberts, you just joined. And at this point, I don't have any information that I've reviewed. And so where things are even at, I don't have a clue. And I don't want to make a decision based on a recommendation. It's a recommendation, no offense to Ms. Turnbull. But I have no information in front of me. So that's my concern at this point.
So we'd ask that we set to the 20th. I'm happy to talk with Mr. Roberts off docket about discovery issues.
And if we are going to have it set over to the 20th, could we at least get clarity on when all of this documentation is going to get to Ms. Turnbull, so we're not here on the 20th kicking it out until September 15th? And again,
I think that Ms. Turnbull should be able to provide her report by the 20th. Either I have the information and I can provide it, or I don't. So at some point, I think it's reasonable that she prepares a report.
So, Ms. Turnbull, where are you at with the timing on this?
I'm substantially completed with my report. I could finish it within a few hours. I'm just waiting on the information that Ms. Baldwin would like to provide.
We have some subpoenas that are supposed to come back this week. And so I'm anticipating, which they weren't due until this week, just the timing that we had to give. So, and those I think would be important depending on what's received.
And I guess my concern, Your Honor, is this is a case that was, the jail report could have been finalized the last week of May, and then subsequent to it being right on the edge of the deadline, further subpoenas and depositions have been taken to just drag this out. So what I'm asking for is some kind of hard date to have this information to Ms. Turnbull. Otherwise, there's going to be potentially new subpoenas, new depositions to drag this into October, November.
There's no reason why it would extend past it. Ms. Turnbull is largely complete and waiting on the data. I should have until the week before the 20th to provide it, because that would just be supplemental, and then weigh however she wants to weigh it.
Your Honor, it sounds like
In regard to that.
And it sounds, sorry, Your Honor.
Okay, enough. So in regard to that, looking at August 20th. I want all information to Ms. Turnbull by August 9th.
Fine.
Then Ms. Turnbull can finish up her report and get it sent out.
Very good. All right, that's it for today.
I'll go ahead and set it over to the 20th.
Thank you, Your Honor.
Thank you.
All right, we are back on the record. I want to remind people, if you didn't hear me before, court starts at 9 a.m. 9 a.m. So please be here at 8:55. Be ready to go at 9 o'clock. I've had a large number of people that have logged in after we have started court. It's disruptive to everything going on. So I would ask you to be early, or at the very least, be on time. I have Mr. Zandy present. This is a Lee and Lee matter. Do we have Jared Lay or Lee? I'm not quite sure.
It's Lee.
Jared Lee? No response. Have you heard anything from him?
We did. He filed a generic formal response to the petition back on July 12th. There was no accompanying information related to a formal response or a declaration in anticipation of today's motion. In response to the petition, looks like he's largely agreeable to everything outside of the marriage being irretrievably broken. So I think for purposes of today, we go ahead and grant the relief. I will get a order prepared and send that over ex parte, hopefully by probably tomorrow. I'm out of legal system today for a signature. I think the only issue we need to resolve now is by what day Mr. Lee removes himself from the family home. We had originally discussed, or at least proposed, July 31st. He was served clear back in middle to late June, so he's had plenty of time. Did speak with my client over the phone yesterday afternoon, who informs that he's made preparations to move out of the house. He's just dragging his feet a little bit to some extent. So whatever date the court thinks is appropriate for him to vacate, I will include in the order.
So based on the files and record, I did review. I did not see a response. I did see that service was June 26, 24. So Mr. Lee had plenty of time to respond to this matter. And so with that, I will go ahead and grant the requested relief, including one, continue living, that the wife continue to live in the family home, that the respondent shall move out by July 31. The wife will use what is in her possession, as well as the 2018 Subaru Impreza, 1990 Jeep Wrangler, and 2012 Ford Focus. And the husband will use what is in his possession, including the 2003 Ford F-350, the 2002 Ford Ranger, and 2016 Heartland trailer. For that, both parties are not to move, take, hide, damage, borrow, against, sell, or try to sell, etc. That's granted. Wife is to pay the rent or lease payment for truck and utilities. Husband is to pay the payment for the 2016 Heartland trailer. 6, each is to be responsible for their own future debts or for debts in their name at the time of marriage. Both parties are not to make changes to any medical, health, life, or auto insurance, etc. That's granted. And each party will pay for the vehicles in their possession or split. This was one I wasn't sure about. Is it fairly equal as far as the expenses? So
I think it's equal enough. I think they're both making good money. He's a longtime West Rock employee. She's a RN at Peace Health. So I think they can both pay for their own credit cards and responsibilities. She pays for her car, he pays for the trailer and his trucks. And I think we're in a pretty equal position.
All right. So just be responsible for what's in their possession then.
Very well. Credit cards in their respective names, if they.
Correct.
Okay. And I will put on the order, he did not appear, and I will get that to you hopefully by tomorrow afternoon, latest.
Sounds good.
Thank you.
We have Ms. Powers. Ms. Looney, are you on this?
Yes, Your Honor.
All right. Do we have anybody else appearing on this matter? Hearing no one. With that, Ms. Powers.
Thank you. This is actually Ms. Looney's motion to establish temporary child support.
Your Honor,
Yes, it is, Your Honor.
Mr. Lockwood just appeared.
Oh, apparently Mr. Lockwood is present here in the courtroom. So you can just have a seat, sir. So when looking at this, Mr. Lockwood, I did not see any response from you. Did you file anything or do anything in writing?
I
was the one who initially filed the
Right,
complaint for it. I didn't send any response as far as this child support
the
meeting.
child support, okay, all right. So, Ms. Looney, apparently this is your motion. I apologize. I looked at the wrong motion when I was reviewing. Go ahead.
Thank you, Your Honor. So yes, we are here on the state's motion for temporary child support order. The child is currently in place. We used imputed wages for both parents. For Mr. Lockwood, we used minimum wage 35 hours per week. He has recently worked at minimum wage jobs. So we were following the statute as to that imputation. That gives him a net monthly income of $22.10. For Ms. Coleman, she is currently a TANF recipient. So we are also following the statute and imputing her at minimum wage for 32 hours per week, which gives her a net monthly income of $2,035. The resulting payment for 2 children is $641. That's $320.50 per child. We're asking for that to begin April 2024. That is the first month the children began receiving TANF of the mother.
Ms. Powers?
Thank you, Your Honor. I represent Taryn Coleman in this matter. We reviewed the state's proposed child support worksheets and are in agreement with them. My client did provide additional information in her declaration that it's her understanding Mr. Lockwood does some Uber and DoorDash. That being said, we believe that the worksheets are appropriate and we're in agreement with the state's proposed temporary child support order.
Mr. Lockwood, anything you'd like to say? All right, based on the files and record, and I did review the proposed order, it appears to be appropriate. The income will be imputed as stated. So with that, I will be signing off on the order. So, Mr. Lockwood, are you okay to put approved for your signature? And then, Ms. Powers, it has your client's name on here. Am I okay to put approved via Zoom on here?
That's fine, yes.
All right, I have signed off on the order.
Thank you, Your Honor.
Thank you.
Curtis v. Wynn matter, it's on for presentation of order.
Good morning, Your Honor. Tanya Green for the respondent.
And I have reviewed your objections. And I've gone through the order. The court is going to adopt the presented order of Mr. Zandy.
And can I clarify on the issue regarding the jail time, since that was not a part of the motion? It was a statement from the court. The court did suspend jail time because that was not discussed.
Zandy?
Yeah, I remember, I thought it was, I think your specific finding was, this is the case that given the conduct of the mother warranted future considerations for that if she didn't cease doing so. So I tried to be as specific as I could from my notes, my recollection of that hearing, and I think it does adequately and accurately state what you had put on the order. So that's what's contained therein. So I asked that you adopt that as such.
And my transcript from your ruling was that you would consider it in the future. It was not something that was ordered or suspended. It was just a statement that it would be a consideration in the future, not that she basically is suspended and would have been in jail today. And additionally, it was not even a request in the motion made by father.
Yeah.
I'll leave that up to you on whatever verbiage you're comfortable with.
So thank you, Ms. Green. That was the one thing that I did see yesterday that I wasn't comfortable with the wording. So I am striking that wording because I did not rule. I did say will consider in the future, which is what I just inserted, will consider in the future.
Fair enough. Thank you.
Ms. Green, are you okay to put approved via Zoom?
I think I still have objections because the other issues, I know you reviewed it, but I think my client would still have objections to the ruling because it wasn't exactly what you ruled on. So you can have appeared via Zoom.
What I put. All right, we're done with that matter.
We actually have another order, our order for the reappointment of JL.
That I do not have.
That should have been submitted last week. I don't know if we want to argue the issue so I can enter it separately ex parte or.
Hold on just a
And
second.
there are some major issues on that GA.
Did you file a proposed order, Ms. Green? Because I'm not seeing it.
Yes, there were proposed orders filed. I believe it was Tuesday. They were delivered to court. So there should be a proposed order cover sheet with order reappointing guardian ad litem. So if they didn't get filed, they were delivered to the clerk's office. I don't know if they got.
I did see it. Here it is. All right. I don't have any written objections to it, but I also don't have an original order.
The objections to that were filed a day later on July 17th, Your Honor, by my office.
And I think I can quickly get to the two issues that are in dispute if the court wants to review the order.
What are the two issues?
On page 2, section 5, the jail duties, we put in that the court or the jail would review the parenting abilities of petitioner, abandonment by petitioner, and domestic violence of petitioner. Our specific previous order, which the court said you adopted our motion, had the abandonment and domestic violence in there, and the parenting abilities were related to the other arguments made in court. Mr. Zandy is asking to include also a mother's mental health evaluation, which was not part of our motion, but was part of the contempt action. So I think that's the heart of the issue, is what exact issues of the jail reevaluating. The jail also asked to strike the language in the second paragraph. The jail is ordered to investigate and file a report only on the issues below, unless the court approves investigation on other issues, just because she didn't want the only on the issues below, so she can do a full report. But I did note that there are any other issues discussed could be affected, could be investigated at the bottom of that paragraph.
Mr. Sandy?
And this is always, unfortunately, the frustration with these is we were all in court. We all heard explicit concerns by the court related to that. Initially, the motion for Ms. Nguyen asked that Ms. Schaefer be appointed to alternatively family court services. Court didn't grant that. Both parties agreed that we need further investigation. But again, you were explicitly clear on what your concerns on this were, and at no time was it the parenting abilities of my client. At no time was it abandonment or neglect by my client, and at no time was it the domestic violence stuff. This all goes back a year or so. This has been investigated by the GAL, and the GAL has returned her report on that. The issues we have now is that mom gave child a pocket knife to take with him to school. You clearly identified concerns about controlling behavior of mom, the mental health. You ordered that she get evaluated for that. And in response to that, again, which was very clear ruling, we get this proposed GAL order that again points the finger at my client, completely ignoring every concern that the court had. So I don't think paragraph 5 reflects accurately whatsoever the ruling of this court. And I would furthermore point your attention to paragraph number 12, which again, in no way conforms with what your order was. That states Ms. Corey is reappointed as the guardian ad litem in this case, and is to file a secondary guardian ad litem report to the court regarding mother's concerns about father's unsupervised visitation with the child. Where that comes from is completely beyond me. Again, that was attempted to sneak in there and shows more controlling behaviors of the mom. She just unfortunately does not get it. Frustratingly to me is this is a very clear order of the court, and we are forced to again respond to this, which in no way complies with what your very specific order was. Ms. Corey is clearly competent. She's adept at what she does. She's good at what she does. She can make conclusions as necessary for the well-being of this child who unfortunately is being brainwashed and manipulated by mom. Don't want to lock in to this order, which is purely strategic at this point.
And Your Honor, I have to state what you mentioned in court specifically was, as to mother's motion, the court will reappoint Ms. Corey to investigate the claims of the mother regarding child. That's specifically what you stated on the record, and whatever else that needs to be done. So putting those provisions that we put in our motion were appropriate. To say that this is strategic and manipulative is far from the truth. I just want to bring that to the court's attention. You granted our motion.
All right. Bottom line is I want a guardian ad litem. I want a broad view of what the guardian ad litem sees as issues. And I'm not going to make it so pinpointed that, so yes, I did grant the reappointment. But that was really pretty much where I would say that I want it to go. So at this point, I'm going to I want paragraph 12 removed.
And then we can strike paragraph 5, the specific detailed marks, and just leave it as any issues.
Yes.
Certainly. We can send that to Mr. Zandy for review and signature. I think we can address that.
Okay.
Thank you.
Thank you, Your Honor.
All right. This is your
Thank you.
motion. Go ahead.
I'm sorry, which motion is it? We have 2 on the docket.
Whichever you want to proceed with.
Okay. I've got the declaration of proof of service for my objections to the presentation of orders that Ms. Gilmore wrote.
Okay, I haven't seen them. Did you file them?
Filed them.
Did you file your objections?
Yes, I did 3 weeks ago.
Do you have a date in particular?
Yes, I do.
It looks like it was filed on July 15th, Your Honor. That's helpful. It's the last declaration.
Yeah.
Okay, I do have it. Let's go ahead and address the order first. Hold on just a minute. Go ahead.
I listed everything out in my declaration. I don't have any more to add.
All right, Ms. Gilmore.
If Your Honor recalls, if you look back to the minutes, the court specifically didn't order my client to pay for the storage unit. My client stipulated to that to avoid additional motion. At the time that we did stipulate to that, the storage unit was in Woodland, and it was a certain size and a certain amount. Wife wanted the storage unit to be moved to Salmon Creek. My client stipulated to that even and helped her move, again, because it was comparable price. Then she asked to have a bigger storage unit, which my client again helped her move over, but indicated to her that he wasn't going to stipulate to ongoing temporary orders to that effect, given it was substantially more. So the agreement that we previously stipulated to has since changed. So it's our position that we either ask for a date certain to end that, which is September 1st, or alternatively, my client should only be paying the amount that he paid at the Woodland storage unit, which we stipulated to at the previous hearing.
That was never stipulated to, Your Honor.
Oh, hold on. Let her finish. Okay.
That's it, Your Honor. This situation has simply changed. My client was trying to be flexible and amicable. He just simply can't pay for an extremely large storage unit without a date certain. So again, it's our position that we have a date certain, i.e. September, or that he only pay the portion that he paid with the Woodland storage unit, again, based on that stipulation that we represented to the court at the last hearing.
All right, so in regard to the, let me get back to that proposed order just a second. So in regard to the proposed order, Ms. Gilmore, I'm going to adopt her proposed order that was filed.
Does Your Honor have a bench copy of that?
I don't.
I'm sorry, which?
Let me go back and find it.
It's been said over several times, so I imagine it got lost.
6/7/24 it was filed.
I can have my staff create a new order with your attention, Your Honor.
All right, so Ms. Fragel, that's the order of the court. Are you okay to put approved?
I don't understand what you ordered.
You can see a copy of the order then. I approved what the proposed order is from Ms. Gilmore, which is filed on June 7/24.
That he only has to pay for it through September 1st?
Correct.
Yes, it's fine.
Okay, she's approved that, so put that on the order and just send it to me for signature.
Understood.
Oh, I didn't approve that. I said it was okay to put that I appeared via Zoom.
Okay, apparently she doesn't approve
I
it. She
do
puts
not.
appeared via courtroom.
Understood.
All right, then the other motion.
And it's my motion for contempt for unpaid child support, Your Honor.
Go ahead.
I put it all in my thing again. I would like to be on record though. According to our legal separation dated June 18th, 2008, Timothy was to begin paying child support on September 1st, which stated $435 for 2 children per month. I did not ask for any adjustments in the last 20 years, even though I became 100% totally disabled, and Tim makes grosses 10 times the amount I do. I've calculated for each child based on the numbers from 2008. And I believe because he never made a payment, not one payment, that money goes to me for what I did to support our children. He never paid.
Anything else?
I have the numbers, the date it was served, and the order to go to court.
Ms. Gilmore?
Your Honor, I'll keep it brief. I know you have a long docket. This simply is a very clearly not a willful intentional violation of the Oregon order. Wife brings this motion in clear retaliation of our last motion, some 6 years after the youngest child turned 18. In reality, my client provided support to these children, all of the support for these children as set forth within these now adult children's declarations that were presented in reply. Not only has he provided support for the children as the children lived with him, he also provided support to wife. I think that it's very clear from her failure to provide a reply that she's acknowledging that my client not only provided her transfer payments of support in the way of giving her money, but also he paid $75,000 of her debt. He gave her $50,000 of his Powerball winnings. Then she also fraudulently took over $15,000 of credit card debt. I understand that this is a complicated case given the fact that the parties did have a legal separation in 2008, but there simply isn't a willful intentional violation of a court order. And I think if anything, this needs to be reserved for trial to address if there's anything owed, because I think that my client can provide testimony that simply there isn't anything owed, as well as if we need to, these children can testify based on their personal knowledge that they were supported by my client as well as wife.
At 7 years old, they can testify to that. Ms. Gilmore?
Sorry,
Stop.
Oh, sorry.
I didn't hear what she said.
I never got a
Never mind.
response at all.
Okay. And then I would just like to note, I apologize, Your Honor. I would just like to note that this is the fourth motion since February. My client has paid $8,000 over $8,000 in attorney's fees, fighting motion after motion. I appreciate the fact that she's a pro se litigant. We just, again, I believe that this motion was brought in bad faith and we ask the court deny it.
Your Honor, the amount he's paid in attorney's fees have nothing to do with this case, except for the fact that he says he can't afford to eat and yet he's paying attorney fees. Mr. Fragel willfully did not file or follow the court order. None of the rest of that makes any difference. He willfully did not follow this order. I am asking the court, since you've already ruled on the 2008 legal separation and given him allowances for that, that you do the same for me.
So here's when I reviewed the documents, that I don't know when you're set for trial or if you're set, you aren't yet,
Nope.
then probably needs to get moving forward.
Yeah.
But meanwhile, I want to reserve this for trial. There are a lot of issues that were brought up. Ms. Gilmore, she indicated she did not receive your response.
I haven't received any.
That was mailed to her. We have a certificate of service to the address. Your Honor, hold on, I can confirm.
Your Honor, I've requested.
Okay, I'm listening to Ms. Gilmore at the moment.
It looks like we served her that Ridgefield address on July 9th, so some 2 weeks ago.
So I think that would be another reason to reserve it for trials. You haven't seen their response or the responses because there were responses from your adult children.
Okay.
So
can I ask that it be a signature required delivery by
they
mail?
need to follow the law that's required, and I'm not going to order additional requirements.
So it doesn't matter that I didn't receive it?
Well,
Or
you,
they didn't send
at this
it?
point, I'm not proceeding forward. You can address it further at the time of
I
trial.
understand. Thank you. Can I ask that trial be soon and that it be scheduled? Because she hasn't even scheduled the trial.
Okay. You can do it too.
Oh.
You set it on a trial assignment docket for scheduling.
Thank you.
Okay.
I will do that.
So we have Mr. Anagnostou and is it Demeter or Demeter?
It's Demeter, Your Honor.
Okay, I had it completely wrong.
It's okay. It's changing in a few days.
Okay. So here's where I'm at with this. I emailed both of you yesterday to let you know I did not have responsive pleadings. I still have not had responsive pleadings. I think Mr. Anagnostou, you may have had something that was received this morning, but I haven't actually reviewed them or looked at them. So I'm not sure what you want to do at this point, but at this point, I just have the one side on each of the matters that are before the court.
And Your Honor, I'm very uncertain. Ms. Fillion herself personally dropped off copies of her response at the courthouse, as she has in the past. So I'm not certain why that has not made its way to Your Honor. Obviously, we want the court to be well informed and have all of the information before making a decision. I think the difficulty that both parties probably would express is that the next docket is August 20th. However, Ms. Fillion feels strongly that her response in relation to his contempt should be heard. She of course, would feel comfortable going forward with the contempt, or excuse me, the restraining order. However, I'm certain he would like his side heard. So I'll let Mr. Agnosto make his position known.
Yes, Your Honor. This is a case where we started this back in late April, early May, filing the Idaho judgment in Calais County. We served Ms. Fillion. The 20 days went by and she didn't respond to that. So we have an order, visitation arrangement, and my client wants to see his daughter. He wants to see Parker. She's age 6, and he hasn't been allowed to see her. There were some visits that Ms. Fillion allowed, and during the exchanges, they would harass my client, where he would just, leave the residence, and they followed him out into the yard and harassed him. And anyway, we're here because we want to visit. My client needs to see his daughter. He needs to see his daughter, and I understand they served my client with their documents only a few days ago, I tried to get a response to that. That would have came over this morning, to Your Honor, and it's just neither side has really had enough time. But if we're going to continue this to your next in late August, my client needs to see his daughter. If not, and we want to go forward today, I'm prepared to go forward with what Your Honor has. But like you said, you don't have his response to her documents, our response to theirs, and with regards to paperwork, the case is not current, but this has just gone so long. The client needs to see his daughter.
Your Honor, in response to that, there's a restraining order. I understand that he wants to see his daughter, but there's a restraining order for very serious and valid concerning reasons. His behavior, my client completely disputes what Mr. Agnosto is saying, that my client was following him, harassing him, anything to his car. That's in her response. She completely disputes that. As Your Honor knows from the restraining order, he's facing some very serious charges that have serious concerns from my client, and as well as his last behavior at her home once he was released from jail and was at her home and was behaving so erratically that the police had to be called. Ms. Fillion, the only type of visitation that she would be comfortable with would be supervised visitation on a weekend day by one of her family members or one of her friends. But the restraining order is in place. She's not violating any court order for visitation, as that restraining order is standing.
So, Mr. Anagnostu, in regard to this, there is a docket August 6th. I'm just gone for August 6th and August 13th. So just so you understand, there are other dockets available.
Your Honor, I'm not available on those dockets. I'm out of town.
So, Mr. Anagnostu, I understand it may not be what your client wants, but at the same time, your client could see his daughter at least, even though it's supervised, with a family member or a friend of the mother. So I would just encourage both of you. I have no problem ordering that in the meantime, the supervised visits, until the matter can be heard. So again, at least your client can see his daughter.
The issue is coming up with an agreement with regards to a supervisor. My client's mother used to be the daycare provider for the child for a very long time. And for some reason, they are now saying, no, she can't be the daycare or the supervisor.
Your Honor, we do not feel
We would
comfortable.
like
Do
my
not
client's
believe that.
mother.
Hold on, one at a time.
We would like my client's mother to be the supervisor, and she could do the exchange. She was doing the exchanges. That eliminates them having any contact. The order says that they're supposed to show up to the Walmart on 4th Plain in Vancouver, which is about halfway between my client's mother's home, where my client is currently staying, and her home in Woodland. We'd like her to meet my client's mother there, and she'll do supervised visits. She'd be with the child 100% of the time.
Your Honor, we do not believe that the mother would actually be there the whole time, that she would make excuses for her son's behavior would be. And additionally, there's been incredibly hostile exchanges between his mother and my client. So that is why my client is not comfortable with his mother being the supervisor. That's why she suggested one of her friends or family members, a more neutral party, but not his mother.
So, Ms. Demeter, I'm trying to figure out who you're proposing. No, stop.
Yes, Your Honor, and my client is present via Zoom as well, and she could give the specific names, but she is proposing either one of her friends or family members.
Who though?
Yes, Leanne, if you can just unmute.
Hello. I'm proposing that my grandmother is retired and has no other responsibilities and would be able to, she offered to supervise the visits.
So here's what it's going to be. I will go ahead and order supervised visits. The grandmother of the mother, so the maternal grandmother will supervise. The exchange will be at the halfway point that was indicated by Mr. Anagnostou. And that it will be this weekend will be the first one. It'll be Saturday from noon to 4. And then I don't know how far this child's coming.
Yes, the halfway point that he had said was between his client's mother and my client, not my client's grandmother. So, Mr. Agnostou, can we come up with a halfway point off docket?
Yeah, we can talk about that.
Okay. All right, come up with the halfway point, and then for at least I want at least 2 visits before the next docket. I do need to make you aware that apparently the temporary restraining order did expire on July 9th.
I believe the court had indicated they were reissuing that.
Okay, we don't reissue without an order being presented.
That was provided to Your Honor. I would ask that it remain in effect, and I will get another copy.
Well, yeah, we don't believe that the child should be included in this restraining order.
The child's going to be until it's heard.
Right.
Okay, so what were you saying? Let me ask the clerk. Yeah, I don't have that order, so I don't know what to tell you on that.
I can get it over just as soon as we sign off.
Okay, so get that to me. I will be signing off on that order. Make sure it reflects exactly what was previously ordered, because I think I did some lining out. Yes. Then again, at least 2 visits on Saturdays from noon to 4, and that will be supervised by the maternal grandmother.
And then when is this going to be heard, Your Honor?
So August 20th.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, this is the Peterson Waymeyer matter. Okay.
Thank you, for the record, Carly Bliss on behalf of Chair Waymeyer, who's the respondent and moving party for purposes of today's motions. We are before the court on my client's request for adequate cause and a request to change the parenting plan. In her initial declaration, she provides to the court her basis for this request, citing significant concerns regarding father's substance use, primarily as it relates to alcohol consumption and marijuana usage around the child. She provides to the court FaceTimes with her daughter, showing Mr. passed out on the couch, FaceTime with her daughter with marijuana and paraphernalia laying around the house in trying to reach for this child. Further, she provides to the court that for the last 3 years, the parties have drastically deviated from the parenting plan in 2016. She provides that pursuant to the parenting plan, she was allotted every other weekend, Friday to Monday. Since about 3 years ago, she provides to the court that she's had no less than 4 days per week with the child, consistent with her days off of work. We do believe that obviously there's some very significant concerns, not only related to Mr's substance use. There was the incident in 8 days pending at this time. As Your Honor likely read in that declaration, Mr. screamed profanities, yelled not only at my client, but at their daughter at a flag football game, proceeded to essentially rip the child out of the vehicle, force her into his own. The child expressed fear and concern, hid behind my client. Mr. then screamed profanities and drove off. That was what led to the protection order. The child, has since disclosed some physical abuse of Mr. and that was reported to counselors. There was, at least at that point, a CPS intake reported by the counselor who was a mandatory reporter. There was significant discussion in Mr's responsive materials of him not knowing that the child was seeing a counselor, my client provides to the court that the child saw a counselor at school. And then once all of these incidents continue to happen, it was recommended that she seek additional counseling. My client has since done so.
Judge, there's been about 3 opportunities to object on child hearsay and information. I could just raise a standard objection now. I think we can consider anything the child allegedly reports. I also don't think we can consider anything that was introduced on reply, which would be the counseling information.
Response?
And the counseling was addressed by Mr. in his responsive materials. My client then followed up with that. Again, as my client said in her reply, she filed this motion pro se. She did not know what she was supposed to or not supposed to. I'm fully comfortable if Mr. Sandy wants to file a SIR reply in response to my client's reply, but I do think that all of the information was initially contained in her declaration and in his response.
So in regard to the records of the counseling, I'm trying to see, usually we look at the medical records and professional.
And I think that's completely appropriate, and I realize that the problem with it is the timing of this. So my client gets this 10-year-old ripped from his custody from the emergency restraining order back in very early May. Mom decides and encourages the child, okay, go see a school counselor. School counselor then apparently, if you take that at face value, informs, or at least mom decides unilaterally put the child in counseling with somebody else. There's no information related to that. On contrary to the counsel statements, Ms. Wademeyer, by my count, this is her 3rd attorney she's referenced since filing of the initial protection order. My client had no knowledge of this, no access to this person, no information up until very, very recently. So again, that's a part of my comments that I will address later, but I still think trying to get anything from the counselor after the fact, after my client filed his responses, is improper and illegal. I'd ask it just not be considered.
So in regard to the counseling and the records there, we can, I mean, I've reviewed them, I read them. So if you want another reply that Ms. Bliss has indicated, we can do that.
I don't, because we have no information. I mean, we don't know about the counseling. This is, again, what you've seen is what we've seen, and he's not been allowed to participate with that, despite the joint decision-making and the fact that he's been this child's custodian for the past 8 years.
Right. Okay. All right. Go ahead.
Thank you, Your Honor. And again, on that same vein, this child is enrolled in counseling. Obviously, further discussions with the guardian ad litem, which we're making that request today, I think it's appropriate for this court to consider. There's a lot of moving parts here, but primarily the basis for my client's request is the significant substance use in father's home, which she's witnessed herself. My client provides to you that not only has she been told by the child, which I understand was just objected to, but my client has seen it with her own eyes on FaceTime. Mr. has dabs, marijuana, paraphernalia laying around the house in easy view of the child. The child can easily access this. Following that, Mr. provides a hair follicle, which shows he's tested positive for 8 times the cutoff limit for marijuana, which further substantiates my client's concern regarding the usage when he did have the child in his care. Not only that, again, there's a current protection order in place given the events that arose in April. The protection order court essentially deferred to Your Honor, encouraged the folks to file a modification. That's what my client did. Again, my client was unrepresented at the time. She filed both the protection order and this matter. She's no legal eagle. She has very limited experience in this matter. As the court likely looked back in the 2016 matter, she was unrepresented therein as well, which is probably the reason that the outcome was what it was back in 2016. Nevertheless, my client has significant concerns regarding this child's well-being. The child is experiencing significant behavioral and emotional distress regarding her father. Since the protection order was entered, there's been supervised contact between the two. The child continues to express concerns with going to visits. My client is simply trying to protect her child at this point. I do believe that there's a basis for adequate cause, given the various allegations made in my client's declaration, but primarily the safety concerns and the fact that the parties have drastically deviated from the parenting plan that was entered in 2016. We are asking for the request cited within our motion, primarily a change to the parenting plan. A guardian ad litem should be appointed in this matter, whether the court deems it necessary for a court investigator to do an immediate return. But in the meantime, we are asking the court to maintain the current status of visits, and that is supervised contact between the child and the father.
Mr. Sandy.
Thank you, Your Honor. First of all, to start with the simple parts, and this is I do represent the non-moving party, primary caretaker of this child, Chesney, who's now 10 years old for the past 8 years, with Chad Pedersen. So I can clarify some of this. In 2016, at the time, the court ordered my client to have custody of the child. Ms. Waymeyer was represented by counsel. She had Mr. Baldwin. She chose, and again, this is contained in the pleadings, she chose not to participate with the GAL. She was dilatory. And again, the findings of the court at that time evidence that and reference that. Furthermore, the court did cite specific concerns related to mom's stability and consistency. I believe it was Judge Warning who stated that he did not buy a lot of her excuses at the time of trial for being dilatory, for not complying and meeting with the GAL, for essentially taking the position of I'm going to choose other activities over that of the well-being of my child. The court found that my client was more capable and apt to provide consistency and stability for Chesney, and that's what he's done for 8 years. This is a child up until early May who was doing very well in school. This is a child who was doing very well socially. This is a child who was doing very well in athletics and extracurricular activities. This is a child who there was no concerns about dad's home. If you look at this, and this is again suited directly to my memorandum of law and authorities, which we don't typically do, but courts generally, and the statute is certainly on point with this, are loath to change parenting plans where the child is doing well, absent a change in circumstance to the non-moving party, that would be my client, or the child. Let's look at the petition. The petition that was filed, and whether she has a lawyer or not, and I would certainly contend she did. I would certainly contend that this is the product and the quality of an attorney who's acting on her behalf, not a pro se who's known, as counsel says, legal. She did have an attorney. That attorney communicated with me at length about this case. We had made certain discussions about the protection order, about the modification like. She did have legal counsel at that time. If you look at the petition, it's exceptionally vague. Washington is a notice pleading state. What does the petition state? It states, well, the only concern raised by mom is my client drinks too much and it's somehow endangering the child. There is no evidence to verify that. If you look at the information contained in the file that was provided by mom, there's a lot of hodgepodge of randomness. Mom goes so far as to try to communicate with a girlfriend of my client from 4 or 5 years ago. The person says, I don't want to get involved with that. Mom then, and this is the part that just absolutely floors me why we keep having these types of cases. Mom then provides you and regurgitates a whole bunch of pictures that the child has sent her under her direction. So mom is telling the child essentially, well, if you want to live with me, go into dad's house and take pictures of certain things. Take pictures of the beer fridge, which I'll talk about in a moment. Take pictures of what your dad's doing. There's one picture I have zero idea. It's in zero context in her declaration where the child is apparently at grandma's house, I'm assuming, with a frowny face. Doesn't look like she's crying. She's just making a frowny face. That's provided by mom. So again, mom is now using the one person in this case who can basically get her what she wants, and that is her 10-year-old child. So again, if we're looking at this from a basic context of, well, I'm going to engage my child and I'm going to have her take these pictures and I'm going to rest solely on hearsay from a 10-year-old who's essentially telling me what I want to hear, being rewarded for that, which is specifically alienating my client, who's been the primary caretaker of a child who's done exceptionally well up until early May, so that she can spoon feed me information so I can take that information to court and say, look, I've got random pictures and this random information that really shows nothing, and a child who says, oh yeah, me and dad look on YouTube for marijuana vapes. When my client says that is absurd, that's never happened. Again, Your Honor is certainly capable of considering what you want to, what's appropriate. That doesn't satisfy the statute. And again, I think the statute is clear on it. Statute states under 26-09260, again, quote, the court shall not modify a prior custody decree or parenting plan unless it finds that a substantial change in circumstance has occurred in the circumstances of the child or the non-moving party. We don't have any of that. Statute goes on, and again, to say it's more than just self-serving statements. It's more than just saying, well, I think there might be something going on at the other parent's home, or a 10-year-old child has given me information at my direction. And she doesn't deny that in her reply. And that just, again, is beyond comprehension to me. Doesn't dispute that, no, doesn't contradict that, just gives information from this 10-year-old child who, again, she is sitting there and actively coaching at home, leading up to this, telling the child, this is what we need to do, this is what we need to accomplish those means. Nowhere in the information, not provided by Ms. Waymeyer, not provided by my client. He tells you otherwise. He says, if she was so concerned about these substance abuse issues, she should have addressed it with me. We don't have that. What do we have? We have a text message from mom in April that says, Chelsea's afraid to go with you, essentially doesn't want to go with you. I'm going to keep her. That's what we have in paraphrasing it. Not, hey, you need to get control of your substance abuse issues. I think you're drinking too much. Chesney's reporting things to me. She's not co-parenting with them. She's not going directly to the source. No, she's using that to her advantage by using a spy, which in this case is their child in common, to go in and take pictures and report back about what dad's doing, most of which my client tells you is complete make-believe. That is not adequate cause. That is a random allegation that's made solely for self-serving purposes, which again, in the McLaren case, directly is on point with that. That is not enough. And again, if we look at the petition, again, that's important. That petition alleges substance abuse issues. My client has not been in any bar fights. He doesn't have any DUIs. He doesn't have any stops for investigation of drinking. He's full-time employed. He's meaningfully employed. This child is going to school and doing very well. There's no earmarks of alcohol issues that we have. Again, outside of a picture. I'll be interested to hear the council's comments on this. Somehow there's a random picture of the beer fridge. He tells you it was before, I don't know, some kind of sporting event, whether that was a Super Bowl or something, in which his buddies were coming over to have a beer. Where did that picture come from? And at whose direction did that picture come from? My assumption is it comes directly from the child because mom's saying, well, if you want to live with me, or I want you to live with me, come be on pro mom's team, take these pictures and do these types of things. So the child is acting essentially as a mole or an investigator on mom's behalf. Again, that's deplorable. My client provides you everything. And again, what does the order say? The order states neither party is to be abused any substances. Very generic. We've been down this path before. She's now claiming, well, he had a cocaine issue from 20 years ago, which by far predates any of the court orders, which is from 2016. She's trying to rehash that in the same manner that Josh Baldwin talked to her about, and she testified to at the time of the trial in 2016, the same issue with the same set of allegations that the court specifically rebuked and did not find held any water. The same ones that the GAL said, I'm sorry, but even back then in 2015, you're going on allegations from 10 years ago then, almost 20 years ago now, and they come back in. If she had these issues and there's anything recent, she didn't provide it. There's nothing to show that. We've given you a UA. We've given you a hair follicle test. We've given you the information that says he's not abusing any drugs. We certainly don't have any information that says he's doing that in front of the child, and why would he? We've got mom who's, again, using the only bit of information she can, which again is funneled through her 10-year-old child who she's trying to get custody of. And again, that's deplorable. Let's look at it further. So we then have mom, and that's the only basis we can consider. I've given you the case law from the Lewis and Bell case, which states that information in a petition or a complaint, in this case it was a civil case, shall be sufficient notice of the claim asserted, and that those that fail to give the opposing party fair notice of the claim asserted and the ground upon which it rests are insufficient. You can't make this up as you go. There's got to be some generality in the petition itself, and we don't have it. And that was drafted by then counsel, but we have as well substance abuse issues. There's none of this about going outside of the parent. There's none of this about danger to the child. There's none of this that they're now trying to sneak in, which again the Lewis and Bell case specifically prohibits. Going so far as to saying the opinion suggests a party who fails to plead a cause of action cannot finesse the issue by later inserting the theory. It's exactly what they're doing here. And the only theory is, again, significant foundational issues about the information she does have, the relevance as to what it's trying to acquire and prove. Most importantly, the foundation and the child hearsay as to where's this information coming from. That's an issue. And again, that does not meet the adequate cause definition contained in my supporting materials. The issue that we have about the kind of spearhead of this was a flag football game back in late April. My client's a coach. He had initially no desire to coach. Child tells him, no, dad, I want you to coach. Other parents, no, you're a great coach. We've given you declarations from those people. We want you to coach. Our kids are comfortable with you. You're good. You're good at it. He's coaching the child. It's a flag football game. It's in terrible conditions. It's cold. It's raining, and they're getting destroyed on the field. Child gets the wind knocked out or goes and sits with mom. Great. My client continues to coach the team. After the game, he's picking up the cones. He's collecting gear and the equipment. Goes to the parking lot. Child is overreacting. He says that. He tells you that. They get to the parking lot, and Miss Waymeyer, again, turned into a little bit of a mama bear, says, nope, you're coming with me. You're not going to get her. Unilaterally telling him what is and what is not going to happen, dictating this in front of the child. My client says, come on, Chesney, we have your birthday party at grandma's house. We got school the next day. Let's go. Child sits there, doesn't want to go, is apprehensive about that. We literally got mom who decides to start playing a game of emotional tug of war with the 10-year-old saying, no, I know it's your birthday. You've got plans for grandma's. You're coming with me. Drives off. My client goes home, says, I'm not going to do this now. We're not going to do this in front of you. It will work itself out. Drives off. Child doesn't have the birthday at grandma's. It's all right. My client goes and gets her, I believe it was the next day, talks to her about things, tells her that sports are not everything. Keep it in perspective, does what a good parent does. There's no signs of emotional defect on this kid. She's dinner with dad. They talk about the week. They talk about school friends. She goes to bed, kiss on the cheek at night, wakes up, and a short time later, he's served with this protection order, which again, this is not a protection order case. Mom waits a month to file the petition, again, under the advice of legal counsel, because she had some then. Waits a month to actually file the petition that we're hearing today. So my client has now gone a period of almost 2 months without any meaningful contact from a child who has been doing exceptionally well under his care until mom decides, you know what, it's been 8 years, you're now 10 years old, I want you to live primarily with me, we're going to set this up and we're going to put it in motion. That's not adequate cause. And again, that's something deplorable to do to a 10-year-old kid who loves both mom and dad. Mom takes it a step further and says, not only going to do that, but I'm going to take you to a counselor. Not just a school counselor, but then we're going to take you to another counselor. Even though your dad has been active in all that in the past, I'm not going to inform anybody of that. I'm not going to give him any input. I'm not going to direct the counselor to contact him. She just doesn't go through and know what she wants to do. Again, building this case and trying to alienate the child from her dad. Not only dad, but the extended family. That's where we're at. That's what's happening with this. And again, that is not the basis of adequate cause. We take a step further. Again, I'm giving you information. The court's well aware of this. You hear this argument routinely. Local rules are the local rules. You can't produce new information that was not contained in the original information that was filed. That's the information from the counselor. That's why we're asking you to disregard that. I think that's appropriate because that's significant. Also significant that my client has had zero input on that and has not been allowed to participate in that. We find out about it exceptionally late. He tells you in his declaration, I suspect she's going to counseling. Doesn't know who, doesn't know where, doesn't know when. He hasn't been privy to that information. And then we get just a whole bunch of information from this counselor on reply after all this information has been provided. What do we have from the third parties? We have provided you with various declarations from parents who Chad has coached. We've provided you information from the neighbor who says that the kids play well together. She has no qualms, has never seen any issue with Chad, that he's always appropriate in his interactions with his daughter. And we've given you information from an ex-girlfriend who says, Chad's a fantastic father. Even though we didn't work out, we still have a relationship. We're still friends. He's a great dad. I have no qualms with him. That's important because those are the three elements that she's alleged in the declaration, not in the petition. In the declaration that he's somehow shortcoming with that and derelict in his parenting obligations, which he clearly isn't. What do we also know? We also know that since custody was awarded under a temporary PO, and Commissioner Carmi has made it abundantly clear, this is a family law case, this is not a PO case. I encourage you to go through the family law court under this cause number. Mom now is telling the kid, okay, well, you're not going to school, you need to go to school. You're going to counseling. Child is not responding well to these current visits. My client told Commissioner Carmi, I will take whatever visitation I can get. I want to maintain the relationship with my daughter. He gets several hours a week. The child is now at the point where she's starting to show these signs of what mom has brainwashed her with since early May. And again, that's deplorable. It's very easy to see what's happening here. It's very easy to see that mom has been doing this over time and trying to manipulate and brainwash a 10-year-old, probably 9 at the time when it started, to get what she wants in this, which is primary custody, which is vindication for what happened in 2016. It shouldn't happen. And we're now taking a well-adjusted, good kid and putting her through the turmoil of trying to make dad some kind of a bad guy. Into, well, your dad drinks too much, go take pictures of his beer. Well, your dad smokes pot, go take pictures of whatever smoking device. Well, tell me about this YouTube. You know, if we had information on that, all coming up, very unreliable, mind you. All allegedly coming from a 10-year-old child who's being coached by mom to go in there and act as private investigator on mom's behalf so mom can meet her goals. I've given you the memorandum of law. We certainly stand by that. I think the facts are very clear on this. I think she's bound under the petition. And again, the Lewis case is on point with that. I think she's bound with the one allegation, which is substance abuse. No information on that. And getting to the parenting plan, what does it say? Don't abuse it. Providing a picture of my client out with a friend, having a drink in a public place that I believe it was McMillan's, showing a picture of beer in a refrigerator, again, in anticipation of a Super Bowl or some kind of a sporting event that he's having in his house, is no indication that there's any abuse of that. This does not come close to an adequate cause finding, especially given the very specific language that a parenting plan is, again, court shall not modify a prior custody decree or parenting plan unless it finds that facts have arisen since the prior decree or plan that were unknown to the court at that time are impacting the child or non-moving party. We don't have that. We have allegations, we have speculations, and she's going so far as to go over the same history this court has already entertained back in 2005 from an allegation of cocaine abuse, 2011, that the court entertained back in 2015 and 16 when this order was made. We're asking you to deny this request for adequate cause. We're asking you to contemplate attorney's fees and costs. And we're asking you that my client have some kind of input on counseling because this child is certainly going to need it now after what she's been put through over the last 2 months with mom, that he should be engaged and allowed to participate in that. We're asking you to try to unring the bell of what mom's done over the past 2 months, which is put my client back in the role he's been for the last 8 years as a primary parent so that this child, again, can continue to thrive in the way she was prior to May 1st. That's our request. I think certainly it's substantiated by the facts and the law, and we're asking you to contemplate some form of attorney's fees and costs. This has been cumbersome for my client and financially expensive. We are asking that any award of fees be paid within day served.
Just briefly, Your Honor, Mr. Stain is correcting one thing in his argument, and the facts are very clear. What has been provided to the court shows there is a substantial change in circumstances since the final parenting plan was entered. Not only do we have substance use issues, which my client provides the dated history of the cocaine usage to show that it's a continuing pattern. There were allegations of cocaine usage, allegations of abuse of alcohol, and those patterns have continued. And my client has shown the court substantiating evidence to suggest that that is accurate, and that is an accurate depiction of what's going on in father's home, and something that very much needs to be reviewed and investigated.
Again, Your Honor, object on that predates the existing order. The court can't consider that it's been that issue's already been resolved to the existing ones. No 191 factors for either one.
Contained within the parenting plan specifically states that neither party is to use or abuse alcohol while the child is in her care. My client is showing you that is exactly what is happening, and that is the basis for her request. To frankly state that you need to provide your entire case within the petition to satisfy adequate cause or substantial change of circumstances, I don't think is supported by case law or statute. My client did provide to the court that there has been a substantial change of circumstances. She then filed a motion for adequate cause, as we do, showing the court what exactly is her basis. My client not only is concerned about the alcohol and marijuana usage, which she's provided to this court, she's concerned about this child's well-being, which is stated within the petition. The incidents that are occurring in father's home, which she goes at length in her declarations to show you, primarily related to alcohol usage, leaving the child with grandma, leaving the child in a bar, being passed out on the couch while the child is screaming and crying on mom's FaceTime. All of these are substantiating, claims and statements proven by evidence provided by my client to show that these are ongoing issues. Nevertheless, father fails to mention the fact that the parties have been doing a 50-50 arrangement for the last 3 years. That in and of itself is a substantial change of circumstance. My client provides to the
object to that, Your Honor. That's not pled anywhere in the petition. That's a specific spot for that.
We'll get to that. I understand.
So, Judge, the fact before the court today is, has there been a substantial change of circumstances since the parenting plan was entered in 2016? I think both parties show that there has been. My client has shown that in the last 8 years, she has become stable, which was a concern of the court back in 2016. She's maintained consistent contact with this child. She has held down the job for the last 3 years at West Rock. That in and of itself, in addition to all of the concerns listed in father's home, are a basis for adequate cause. We are asking the court to find adequate cause. At a minimum, having a guardian ad litem or a court investigator do an immediate turnaround is even sufficient. If my client needs to file an amended petition to include all of these bases, obviously we're willing to do so, but for the purpose of court efficiency, the fact that Mr. Zandy and I have been waiting several weeks to get this matter before the court, obviously the protection order court had been waiting for this court to hear this matter. For expediency purposes, we're asking the court to allow us to move forward with our motions as they've been laid out.
So here's where I'm at, that the court does see that there are procedural issues in this matter. One, the petition, I believe, under case law, and if you can show me something else, I'm more than happy to look at that. And so that's one thing is, and that before we can proceed forward on adequate cause, the court does believe that it needs to at least give notice of the basis for what it is that's going to be pled in the pleadings. Again, if you can show me something different, I will consider it and look at it. Meanwhile, the other question is whether or not a guardian ad litem, because there is no doubt there are substantial concerns in regard to the child in the sense of some of these issues that are at question of whether or not it's child hearsay. And from looking at a number of the issues that were stated in the pleadings, it is under child hearsay. And so the court cannot consider that because there is no exception when it comes to family law, as much as I see it too often. So the other question that I've had, and maybe you can answer this, I don't want a scenario where a guardian ad litem necessarily determines adequate cause, but the question is, and I think I know pretty much clear on the answer, but I just wanted to ask you, what is your thought in regard to appointing a guardian ad litem before the finding of adequate cause? Do you think that can be done or not?
You want to go first or want me to?
I can go first. I think the court has, in the past, when there has been essentially a coin flip as to whether or not there has been a substantial change, I have seen the court appoint a guardian ad litem just for the sole basis of, is there a concern rising to the level of adequate cause? I don't know if there's any specific case law or statute to refer to, and I'm more than happy to do the research on that.
I would say it's absolutely inappropriate. I don't think you can appoint an investigator, putting the cart before the horse. You can't appoint an investigator, say, hey, what's going on with this case? I mean, it's you take everything on the pleadings. And again, the case that we gave you is pretty on point with that. So again, you can't, then I get it. And this is certainly not a docket today. I want to be a judicial officer. And there's a lot of cases on that, some might include, but you can't appoint a GAL absent of finding of adequate cause. And you take the pleadings as they come. That's what we're at today. She's had now almost 3 months to perfect those, and she hasn't. So I don't think you can do that, to answer your question.
So here's where I'm at today. The court cannot find adequate cause based on procedural issues that are before the court. One being the child hearsay and the amount of hearsay that is proposed and put forward to the court for purposes of finding adequate cause. The second thing is the notice issue and whether appropriate notice was given by the petition. The court finds that it was not. And that if it's going to be pled, then notice needs to be given to the other side. So what I'm going to do at this time is find there is no adequate cause without prejudice, meaning for those that don't understand means that it can be brought back, but things need to be cured before we proceed forward. So because the court does have substantial issues in regard to the issues that were raised, but procedurally cannot find that those procedurally can be put before the court at this time.
So the existing parenting plan is in effect. So I assume the child will be returned to my client this afternoon at 5 o'clock.
I think she's, excuse me, I think my mom's due to pick her up at,
That's under the old order.
okay, so yeah, but
My suggestion would be to exchange the child from Hall of Justice today at 5 o'clock.
I think we solved the remaining issue of the pending protection order. That's still-
Right, I know the protection order is there and I don't know, did she just not rule on it?
That's
There
correct.
yeah, there hasn't been any. interview.
So I expect
Just
that.
deferring to this case, to your honor, to give guidance on it. It was abundantly clear from Commissioner Carmi, this was a family law case. That's where you need to hammer it out.
Okay, so what I would suggest that you do, I don't know if it's on for Monday, is appear back before Commissioner Carmi, let her know what occurred in this court. Again, it's without prejudice, so we'll see what happens. Meanwhile, I would say before there's an exchange that needs to be clarified with Commissioner Carmi before that proceeds.
So absent the protection order that's in place, and there's not, we've just been, obviously council member, well, together, we've just been kind of piecing the visitation together. There is no protection order. Certainly, I understand what you're saying, and I think it's makes some sense to some degree. I just don't want this child to continue being, our opinion, I know it's disagreed and disputed, manipulated by mom and some of this gamesmanship. I think at least having overnights with dad, at least putting them in equal position for the next week probably makes some sense.
So here's what I want you to do, is that at least what I'm hearing is it's been a 50-50 plan. Are you, I know that doesn't necessarily reflect, Mr. Zandia, is your client agree with that's kind of where it's been or not?
Not exactly, but they have strayed, I think, a little bit maybe from the existing plan.
Okay.
And again,
So-
I didn't get into depth with him about that, so take that with a grain of salt.
So here's what I'm going to do is I'm going to go ahead and no exchange until Monday after you see Commissioner Carmi. I want it clarified whether or not, once she knows how I ruled, what she's going to do in regard to the protection order. And then once she rules, if she just says she's not going to proceed on it, then you know it needs to go back to the current parenting plan.
Yeah. And I anticipate that's what's going to happen, but
Is your honor putting that on the document on the 29th? It's currently set for the 5th, just not this coming Monday.
Yes, let's add it to the protection order docket on Monday.
are you here?
I'm not set to be out of town, but if it's worth putting it on that docket, then I keep myself.
August 29 at 9. Very well. All right.
Okay.
Fees?
No fees reserved at this time. Gallagher.
Amy Powers here for Cody Gallagher. Mr. Gallagher is present in my office with me.
Good morning, Your Honor. I'm Michelle Moore. I represent Sarah Stanley. She is also here with us on Zoom today. And when you are ready, I have a preliminary matter.
Okay, it'll be just a second. 4-7, we have Ms. Powers. I do not see Ms. Day. I don't know if she's on this. We have Ms. Moore. So Ms. Moore, you had a preliminary matter?
Yes, Your Honor. We filed an objection to Mr. Gallagher's filings. I don't know if the court has had an opportunity to review that. His pleadings were not served according to the court rules, which require motions and all supporting documents to be served 21 days before any hearing. Ms. Stanley was not served until the 8th of July before I came on the case, and that made it impossible for her to respond timely, as the calendar for the case said the response was due on the 9th. And this prejudiced my client, of course. Mr. Gallagher did not give any reason in his pleadings for good cause for his deficient service, which is likewise required by the rules. On the 15th, he filed an additional document, again, not properly served, and this was sent directly to my client, even though we entered our notice of appearance on the 12th of July, and Mr. Gallagher was aware Ms. Stanley was represented by counsel. 8 days
I would
later.
object to that piece in particular. I was just
Ms. Powers, just a minute. I do not see a notice of appearance. It was just filed yesterday, is my understanding.
Your Honor, we had a notice of appearance that was filed previously. We filed it again yesterday. We mailed it to the clerk before my paralegal verified with the clerk before it was refiled yesterday that it actually was being docketed. And so I'm not sure why that's not showing up, but I will also say that we sent an email to counsel with the notice of appearance, ask if she would agree to electronic service, have not received any response to that. And so there's been both a mailing and that electronic service. And then yesterday we had our process server again serve copies of all of the documents we filed as well as the notice of appearance again.
Ms. Powers?
Thank you.
And
Ms.
Your
Moore-
Honor, I'm sorry to interrupt, but I would ask for counsel to state the basis of her objection. I didn't hear anything.
Well, let me hear from her first. Ms. Powers?
Thank you, Your Honor. Ms. Moore is correct that we were not able to get Ms. Stanley personally served until July 8th, although we had tried much earlier. So it is correct under the court rules. She has additional time to respond. We were personally served with her response yesterday afternoon. I would like an opportunity to reply. So at this point, I would ask the court to set this over to August 6th so that we have an opportunity to address those things. Ms. Moore has made some very concerning allegations against me professionally that I want to be able to reply to. So I would ask that this gets over to August 6th and that the court extend the current order keeping the children with my client until this can be heard.
Ms. Moore?
Your Honor, procedurally, Ms. Powers still has not stated any evidentiary basis for an objection. So what I hear her asking for is simply that the matter be continued. And at the court's convenience, I'd like to continue my preliminary matter, which is an explanation of why we are objecting to Mr. Gallagher's filings. And if the court sustains our objection, then his filings are going to be stricken from the record, and there's no reason for this hearing this morning, and there's thus no reason to continue it.
So Ms. Powers, let me hear what else Ms. Moore has to say, and then we'll go from there. Go ahead, Ms. Moore.
Thank you, Your Honor. So I believe the last thing that I was saying before Ms. Powers objected was that 8 days later, we still haven't received a copy of any documents. My client has not harmed the children. She's not made threats to anyone. To the contrary, she protected the children as she became aware of safety concerns. Mr. Gallagher requested an order for himself and provided no evidence at all of any danger of harm that might befall him. Currently, there is a restraining order against my client that protects only Mr. Gallagher. There hasn't been one word in any of his pleadings, which are more than 80 pages in length, that says anything about her being a threat to him. In addition, all of the allegations that he raised are, one, untrue and unsubstantiated, and two, occurred months and even years ago. He has attempted to, or not attempted, he's actually received a restraining order fraudulently. There's no basis for any restraining order at all, much less an immediate order. Not only has he made untrue statements to the court, but he filed evidence that disproved his own assertions. His entire argument seems to be that Miss Stanley makes poor choices in romantic partners, which seems ironic coming from her ex-husband. If Mr. Gallagher felt there was adequate cause to modify the parenting plan, then the appropriate action would have been to file a petition to modify and schedule a hearing for temporary orders, not an emergency restraining order that disrupts the children's stability and is a violation of the parenting plan. I think the court should be aware that in 2017, Mr. Gallagher attempted the exact same tactic in trying to gain custody, and that motion was dismissed. So he's also violated Court Rule 11. He's engaged in abusive use of litigation in these filings. We showed that my client, in the brief time that we've had to respond, that she has at all times co-parented with him in a healthy way, made him aware of any issues with the children, which we demonstrated through sealed medical records and other communications. Mr. Gallagher, conversely, has not done this. He did not discuss any of his apparent concerns with my client at all. He just got a restraining order.
Again, I would object simply because I was just served with this yesterday. I have not had a chance to reply to the court.
All right. So,
Your Honor, my objection is based on the fact. I'm sorry.
Stop, please. At this point, I have nothing in writing from you, Ms. Moore. Nothing. So I haven't reviewed anything that you're talking about.
Well, I have conformed copies of the documents. We also provided bench copies. I do apologize, but part of the for the court not receiving those, but part of my objection is that Mr. Gallagher has not followed the court rules here. They require him for any hearing to have it heard in 21 days. For a restraining order, he's entitled to be heard in 14 days. That didn't occur at all. And so my client has been prejudiced by not having the personal service that is required by statute. Didn't get the personal service until the 8th of July, then had to get an attorney. And so for Ms. Powers now to be objecting that she hasn't had an opportunity to respond when she didn't timely file, I think is a little bit of the pot calling the kettle black. We've done the best we can under the circumstances. The fact of the matter is a restraining order was granted. It was based on untrue statements. The court rules were not followed. There has been no evidence of any immediate danger to the children. We're asking the court to just strike the improperly served documents and to return the children to the mother and for the parenting plan to proceed as it is supposed to. We're also asking for fees and sanctions for having to defend this action. Again, this is the second time he's attempted this type of legal tactic. And the children have lived in Kittitas County for the last 4 years. All of their friends, the witnesses, records, caregivers, educators are all in Kittitas County. Cowlitz County, while it was the original seat of the divorce, is now an inconvenient forum because all of the evidence and witnesses are in Kittitas County. So if the court does find that the matter should proceed forward, we would ask that you declare Cowlitz County to be an inconvenient forum and remove the case to Kittitas County. Thank you, Your Honor.
So first off, I have not reviewed any of Ms. Moore's filings. They were filed yesterday. Apparently, they have not been scanned into Odyssey. I understand that service was not until the 8th, but we are currently on the 23rd. And so the court doesn't quite understand why it took so long to finally get some documents filed. Regardless, understanding the timing of matters, the court is not going to strike. I understand their allegations, but again, I do not have anything in front of me to weigh. And so what the court is going to do at this time is set this matter over. I can set it to August 6th or August 13th.
I would ask for August 6th. The kids start school at the end of August, and we'd really like some weigh-in from family court and from the court about where the kids should be going to school. So I think time is of the essence. I'd ask for August 6th.
Ms. Moore?
Thank you, Your Honor. I can be available on August 6th. I will have to move some things around on my calendar. I will note that the children will have been with Mr. Gallagher for more than a month at that point. And I think the issue of whether there is a need for an immediate restraining order should actually be decided by the court today. The restraining order is for Mr. Gallagher only, and it says that there is a danger of immediate harm. Even if the court has not had an opportunity to read our documents, I assume that it has read the ones that were filed by Ms. Powers, and they show that there is not one shred of evidence, no statement, true or not, in Mr. Gallagher's filings that shows he is in immediate harm.
Ms. Powers?
Thank you, Your Honor. I think that counsel and I are reading the immediate restraining order differently. My reading of the immediate restraining order and our purpose in bringing the motion for immediate restraining order is that the kids were in immediate danger, not my client, Mr. Gallagher. The relief that was requested and granted in that order was that the kids would stay with my client pending further hearings. We submitted police reports to the court. We submitted school records, but the most immediate issue is that the mother's most recent fiance has now been charged with 5 different felonies for crimes against the party's child. Prior to the summer schedule starting and my client receiving the kids for the summer, the mother had not gotten the kids into counseling. We've got these criminal matters going on, and Ms. Stanley had indicated to my client that even though there's a criminal no contact order between the ex-fiance and the child, he was still sited close to the home. The mother and kids were residing in Cle Elum, which is a very small community, and there's now 2 men in Cle Elum who have protection orders protecting the kids from these 2 men. That's where the immediate danger comes from, is that we've got these men in this community, these kids aren't being protected, the daughter hadn't been put into counseling yet, and we provided a lot of documentation about those things. We would ask that the court extend the restraining order. Our proposed parenting plan is that the mother can have every other weekend until she she gets further treatment. If the court deems it appropriate, we would be in agreement with her having a weekend visitation between now and August 6th. But we ask that it not be more than a weekend, given the documentation that was filed, that the mother has only had 2 relationships since this divorce, and both have ended with restraining orders against these parties protecting these kids. There is significant harm and concern here. And so we ask the court to continue that emergency order.
Your Honor, number 4 of the restraining order says this order protects Cody Orion Gallagher. And then number 5, it says that the restrained person and protected person were intimate partners because they're parents of a child in common. The restraining order is for Mr. Gallagher. It is not for the children. It does have a residential provision in it, but it does not cover the children at all. Therefore, there is no basis for it. There's no basis for Mr. Gallagher to be protected at all. And counsel, if she has had an opportunity to read my filings, will realize that she has misstated the facts here. There are not 2 men in Cle Elum against whom Ms.
Again, I'd object.
One of them is in Kelso. So
I just received this yesterday and haven't had an opportunity to review it with my client and respond.
Well, considering that this is about the best interest of the children, I think the court needs to hear the evidence that might be important to that. I'm sorry, Your Honor, I didn't mean to speak over you.
So, Ms. Powers, just looking at the order that was signed by Judge Evans, it does not appear to include the children. I see the motion does, but the order itself that was signed off does not.
That was a drafting oversight on our part. The section 12 of the order that was entered indicates the children will continue to reside with Cody. I don't know how the children were listed in section 4, but that was the intent and is reflected in the motion as well. That's the relief that we're asking for, is that the kids remain here until we can have a full hearing.
At that point, Your Honor, will have been more than 28 days past. There's no good cause. And I don't know what more to say at this point. The order clearly protects only Mr. Gallagher. I can appreciate counsel's surprise at the misdrafting, but that's not our issue. The fact is the court ordered a restraining order for Mr. Gallagher only. It does have a residential schedule provision in it, but it doesn't protect the children. The children should be returned to mom per the parenting plan. Nothing that he put in his declarations was anything that's immediate. Ms. Stanley broke off the engagement immediately when she discovered what was going on. There is no present danger to the children. And in addition, his having this restraining order is a violation of the parenting plan, which has a clause in it that directly relates to the impact of being consistent with the children. So now they have something going on. They don't know what it is. They can't talk to anybody about it. And his allegation about there not being counseling, this is something that you do in co-parenting. He seems to have missed his obligations as a parent and has put everything on the mom and is blaming her for having dangerous people in her life when she attempted to protect the children and did everything that she could in relation to that. So we can come back and have another hearing, but there's no reason for a restraining order to continue at this point.
So I have said that the matter is going to be set over to August 6th. I will continue the restraining order with the amendment that it protects the children as well. The mother will have visitation for the weekend. She's not to have any romantic parties or any significant others. I'm not sure what to call them, boyfriends or whatever you want to refer to them. So significant others or boyfriends, that this matter, like I said, will be set over to August 6th for hearing. And then we're on the 23rd. So the mother, you said the weekend, she can have either the 26th or the 2nd.
We'd like this weekend, Your Honor. And in relation to filing a response, which we've not done, we've only filed an objection to Ms. Powers not observing the court rules. So we would like to file a response. Could we get that to the court by the 30th?
I was served with responsive pleadings yesterday along with the objection.
The objection was what you were served yesterday. The attachments with it were in support of those objections.
All right, so if the 30th, will that give you enough time, Ms. Powers, to my concern is, let's see, we're on the 23rd, so I want the responsive pleadings by the 29th. Whoever hears it on the 6th, again, I don't have anything in front of me, so I don't know what's there. Ms. Moore filed by the 29th. And then Ms. Powers, if you would reply right away by the 2nd.
Okay.
And Your Honor, I do apologize again that you didn't receive the bench copies. We did have our ask our process server to provide those yesterday. So is there an email that would be convenient as a backup for that?
I would just provide the hard copies and put bench copies. I don't, if they were just filed yesterday, that's why they haven't gotten to me yet.
Okay, thank you, Your Honor. I appreciate that.
Does the court want me to send over a new ex parte restraining order?
Yes, please. And with that, Ms. Moore, yeah, just send the one. It's an ex parte, so I'll sign off on that. Just note Ms. Moore was present via Zoom.
And I'll communicate with Ms. Powers, Your Honor, to arrange for the visitation this weekend.
Okay.
Thank you.
And just one last clarifying question. Do you want me to you want me to send over a hard copy of the order, or do you want me to email it and CC Ms. Moore?
Hard copy, please.
Okay, thanks.
Bear with me one moment. All right, there we have Ms. Powers representing Cody Gallagher, and Ms. Powers is present. And then I see Ms. Moore is present, and she's representing is it Stanley now?
Yes, Your Honor, it is. Good morning.
Okay. Good morning. And then we also have
my client is also present via Zoom, Your Honor.
Lovely. Great. Welcome to you, Ms. Stanley. And then
Mr. Gallagher is present in my office.
Extend our welcome to him also. And then guardian ad litem is noted as Ms. Day. I don't know if that's accurate at this point, but
Ms. Day was dismissed. She'd been involved back in 2017.
Great. Thank you. All right, we're here on a couple of different matters. One is Mr. Gallagher's motion for adequate cause to modify a parenting plan, and then we're also here on Ms. Stanley's motion for a motion to change venue from Cowlitz to Kittitas. So maybe what we could do, if we could first address the motion for adequate cause, and then we can address the motion related to the change of venue. So this is Mr. Gallagher's motion for adequate cause. So I'll hear first from Ms. Powers, then I'd be happy to hear from Ms. Moore.
Thank you.
Thank you, Your Honor. Before I proceed with argument, I just want to make sure that did the court receive our rebuttal declaration and the affirmation of counsel? They were filed with the court on Friday, August 2nd, and bench copies were delivered as well.
Pulling up the case file now.
Judge Haan had given some later response and rebuttal dates in this case.
See an affirmation of counsel filed August 2nd. Talked about documents filed and served timely, the RPC violation, abuse of litigation, attorney fee and sanction. So I did read that. And then there's also a rebuttal declaration of Cody Orion Gallagher that was filed on August 2nd. So yeah, I did review that.
Thank you, Your Honor. Let me jump into adequate cause then. Well, and first, will the court want me to address the CR 11 motion and RPC allegations?
No need.
Okay. Perfect. Thank you, Your Honor. So to give the court a little history here, Mr. Gallagher and Ms. Stanley married in 2007, divorced in 2016. There's been a parenting plan modification filed in January 2019, a notice of intent to locate in 2020, and a parenting plan modification that was filed in February 2021. The parties have 2 children together, Ireland, age 14, and Sawyer, age 11. We filed our petition to modify the parenting plan based on some pretty serious concerns that arose this spring. The primary concern being that Ms. Stanley has had 2 different partners since Mr. Gallagher and her separated, and both of those relationships have ended in protection orders. And most seriously is the most recent relationship with Mr. Mortensen. We've detailed in our declarations for the court that Mr. Mortensen was living with Ms. Stanley and the children in Cle Elum and made some pretty bad decisions and videotaped and photographed the daughter Ireland while she was unclothed in the bathroom. Miss Stanley became aware of this situation in February 2024, but did not take action, did not notify the police, did not notify my client until May 22nd, 2024. We filed the police reports for the court, which lay out the timeline here. According to the police reports, Mr. Mortensen was still in the home until the beginning of May 2024. Although Miss Stanley had become aware of everything, I believe it was February 12th, 2024. This is our biggest concern here. She became aware that these videos had been taken. She allowed him to continue to reside in the home. In her responsive pleading, she indicates that she had confronted Mr. Mortensen in February and that he threatened suicide, and that she did her best to calm the situation down and get him out in a timely manner, but she still let him stay there until May. Also, Ireland didn't receive any counseling during this time period. To date, Mr. Mortensen now has 5 felony charges pending against him for his actions towards Ireland. When my client got the kids for their summer visitation, and let me back up, the current parenting plan has the kids with Miss Stanley, and Mr. Gallagher gets every 1st, 3rd, and 5th weekends. And then in the summer, they rotate. Mr. Gallagher gets 3 weeks, and then the mother gets 2 weeks with the kids, and they repeat that through the end of the summer. So when Mr. Gallagher took the kids this summer, Ireland had still not been put into counseling. He indicates in his rebuttal declaration that him and Miss Stanley had had 3 different conversations about counseling, and that there was an agreement that he would start counseling when they got here. Ireland has now started counseling. We provided a rebuttal declaration explaining that although our action was primarily based on these concerns that occurred for Mr. Mortensen and the immediate dangers that posed to the kids, we had additional concerns come to light. We had Sawyer, who has started disclosing abuse that he suffered both from Mr. Mortensen and also from Mr. Gunnels, which was Miss Stanley's first live-in partner and fiance prior to Mr. Mortensen. And we've now had a lot of information come forward that shows this concerning pattern. We have 2 men in Cle Elum. Miss Mortensen or Miss Stanley in her last declaration indicates that Mr. Gunnels no longer lives in Cle Elum, but he had lived in Cle Elum prior. We've got these 2 men who now have protection orders protecting the kids from these 2 men, both from Mr. Gunnels and from Mr. Mortensen. Mr. Mortensen has the criminal no contact order with his 5 felonies pending. We also submitted to the court school records showing that Sawyer has not been doing well in school. We showed to the court that he had good grades and was testing at grade level in 3rd grade. In 4th grade, things completely fall apart. He almost failed 4th grade. He'd missed 36 days of school, was tardy 8, left early 8 days. He tested lower on the Smarter Balance assessment in 4th grade than he had in 3rd grade. We explained that the school reached out to both parents. My client became a main contact and started doing homework with Sawyer over video. Miss Stanley says she still was involved, and she was. We didn't realize that his school attendance was so poor until we had gotten the school records when we were preparing to file this case. 5th grade went a little bit better. Grades improved some, but he's continued to have academic and behavioral problems, and he missed 26.5 days of school and was tardy 4 days again. We indicated in our rebuttal declaration that Sawyer has disclosed mistreatment by both of Mom's fiancés, and that was occurring during 4th grade. We would submit that some of the problems we were having in 4th grade were a result of the home life that Sawyer was having. At this point, we've got 2 kids who have been put in compromising situations by the 2 men that Miss Stanley has had in her home with her. And these kids need a safe place to be. They need to be protected, especially Ireland, as she processes being the victim of the crime that she just experienced. We asked the court to find adequate cause here. The current parenting plan contains 191 restrictions against my client for alcohol abuse. My client has continued in his sobriety, but he is not asking the court to remove the alcohol testing provisions. We are asking the court to find 191 restrictions against Ms. Stanley for her failure to protect the kids from unsafe partners. We're asking the court to restrict Ms. Stanley from introducing the kids to new romantic partners for at least a year. And we're asking that she be required to do treatment for victims of domestic violence and engage in counseling. If the court grants adequate cause, we're also asking the court to enter a temporary parenting plan, keeping the kids here with my client. And we're asking for joint decision-making, and we'd ask the court to limit Miss Stanley's time to 3 overnights in a row until she's completed treatment. So she would do every other weekend, and that time should be restricted so that no third parties are present during her visitation. We're also asking that the court appoint a court investigator to get some quick information. The kids are supposed to start school on August 28th, and we're asking that a court investigator do a quick turnaround so that we can review this on August 20th to figure out where the kids should start school in the fall. So those are our requests today in terms of adequate cause.
All right, thank you, Ms. Powers. I have a question for you, and if you don't know the answer, I'm sure Ms. Moore may know the answer. There was indications that when the photos came to light, that there was an indication that Mr. Mortensen was suffering from a pornography addiction and was seeking treatment. Was there any indication that he actually obtained and was engaged in any treatment during this past 8 months?
All I can speak to is what's contained in the police reports, which indicate that last summer, Miss Stanley found that he had done a search online, effing my stepdaughter, that she had confronted him. He had indicated at that time he had a pornography addiction. I am not aware of any additional information about whether or not he sought treatment.
Thanks. And then also remind me that the county where the criminal charges have been filed.
They are in Klickitat County, which is where Cle Elum is located.
Or is it Kittitas?
Kittitas, I apologize.
Okay.
I'm getting my K counties confused.
Okay. All right. Great. Thanks. All right, Ms. Moore.
Thank you, Your Honor. It appeared to me that Ms. Powers' argument actually went a little bit beyond adequate cause, so I'll respond to her statements, if I may, in that regard. Mr. Gallagher's statements, I believe, at best are disingenuous, and he has filed an unnecessary motion here. The evidence that we filed with the court demonstrate that Ms. Stanley has attempted to co-parent with him in a healthy way at all times. She has discussed with him at length the children's medical care, school challenges, and the protection orders. He's at no point said he had any concern. In fact, he has been supportive in the past. He, however, has not co-parented in a healthy way. He comes to the court citing concerns about things that happened months, weeks, and years ago, but he's not provided any evidence that he even attempted to discuss these concerns with Ms. Stanley. This is not the first time that Mr. Gallagher has tried to use a restraining order as a mechanism to change custody and eliminate his child support obligation. He did this before, I think it was 2017, and I believe Your Honor, in fact, dismissed his last attempt at a restraining order. He has again used an immediate restraining order to improperly modify the parenting plan and prevent the children from seeing or talking to their mother. They've only been able to do this recently due to Judge Haan's order at the last hearing. Mr. Gallagher's primary purported basis for requesting a restraining order is that Ms. Stanley has obtained protection orders against Mike Gunnels and Travis Mortensen. Neither of these men is in the children's lives any longer. Neither has any access, so this really is a moot issue. And Mr. Gunnels, in fact, is now living in Kelso. Mr. Gallagher is attempting to use Ms. Stanley's very act of protecting her children against her. I'd like to point out that she has always used her best judgment to protect her children and remove any threat to their safety, including Mr. Gallagher himself. In hindsight, could she have done something differently? Absolutely, she could have. Do people disagree on what might have been the best course? Of course, that's going to happen. But in this case, when she first addressed when she first saw the search on Mr. Mortensen's computer, he made a very credible argument. You know, I just was on there and this thing popped up. We all get stuff every day on our internet browsers where the computer is trying to figure out what we might like to read. And so that seemed to be a reasonable argument. When she found the videos, she was horrified. She again approached him. She was very angry about it, and he threatened suicide. She felt as though she didn't have any choice at the matter but to be more measured in how she got him out of the house. But at that point, the children were not around him and in his care without her being there. And as regards the counseling for Ireland, she was not aware that any of this had happened until the charges were filed later on. So when Ms. Powers indicates that she wasn't enrolled in counseling, Ireland wasn't even aware something was going on. The parents had talked about counseling. They were in agreement about it. Mr. Gallagher makes it seem as though Ms. Stanley failed to act, which is not the case at all. They agreed that she would start counseling when she came to her dad's, which was coming up soon. And then when she returned home, she was going to have counseling here in Cle Elum. The whole point of a protection order is to protect people, no matter where they're located and no matter the size of the town. That's why they're entered into a national registry. I've found no legal authority that addresses living in a small town when there's a protection order, and Mr. Gallagher has not cited any. And in addition, he understates the population. Cle Elum is a bedroom community with thousands of residents who maintain primary residences elsewhere and are not included in the city's census count. And I even lived in that community and rarely saw anyone I knew at the grocery store. Mr. Gunnels is now living in Kelso, the same town as Mr. Gallagher. And Kelso is also not a large city as I understand it. So Mr. Gallagher's argument that Kelso is safer is without merit. In his rebuttal declaration, I believe that Mr. Gallagher finally reveals to the court the real reason he has brought this action. Even though he has moved on and has remarried, he doesn't think that Miss Stanley should do the same, and he's trying to control who she sees. In reference to the school issues, each parent has equal access to school records. This is in the statutes, and this is even in their final parenting plan. Despite this, my client has co-parented with Mr. Gallagher. She's shown evidence of that in the text that we filed in a very healthy way, bringing things to his attention and attempting to resolve any issues with his involvement. He's not raised any concerns prior to now. Conversely, he now places complete responsibility for Sawyer's challenges on Miss Stanley's shoulders. He also has a responsibility as Sawyer's dad, and he's failed his son in this regard. He's attempting to use that against Miss Stanley and now change custody. I'd like to point out that page 9, line 14 of the parenting plan says the children's interests are best served by a full and regular pattern of contact with both parents, responsiveness and cooperation by both parents, involvement by both parents in aspects of the children's needs, and a reasonably consistent routine of activities, values, and disciplines throughout both homes. Absence, inconsistency, and conflict are opposed to the best interests of the children. Yet, Mr. Gallagher has introduced absence, inconsistency, and conflict. This matter is not in the children's best interest. I believe that he is having conversations with them that are not appropriate. He's using this opportunity to coach them. He now states that Sawyer is alleging that there was some abuse and has shared some things with him. Well, first, he hasn't shared any of that with my client. So again, he's not co-parenting. And second, any abuse that occurred in the past is no longer an issue. There's a protection order. Mr. Gunnels is prohibited from contact, and he's not in the county any longer. In his motion, Mr. Gallagher is saying that there's an immediate danger. This is not true. He has not shown that there's any immediate or irreparable harm that would befall the children or that warranted an ex parte hearing. In fact, there's no evidence at all for any reason for a protection order that protects Mr. Gallagher, yet one has been issued. There's not one statement, even among his untrue assertions, that addresses any threat of harm to him. There was no emergency other than his attempt, in this case, as it was the last time he filed a restraining order, to get the children in his care, believing that by doing so, he could put events into place that would result in his being able to keep them and stop paying child support. Ms. Stanley has always been flexible with Mr. Gallagher in regard to additional parenting time, and up until this point, they had been able to do that amicably. She's still willing to do that. She's always been willing to do that, but Mr. Gallagher chose to bring this action and incur significant legal fees for both parties instead of talking to her about this. And I might note that his income is more than 5 times that of Ms. Stanley. So financially, he has a lot more power in this situation. Regardless, over and over, we see that Mr. Gallagher is not credible in his statements to the court. So we're asking the court to deny Mr. Gallagher's motions. We're asking the court to find that there is not adequate cause and to return the children immediately to Ms. Stanley's care and to provide makeup time for the time that she has missed with the children. And we're further requesting that the court order Mr. Gallagher to pay the entirety of Ms. Stanley's attorney fees for having to defend this action pursuant to RCW 2609-140. And I deem Mr. Gallagher's actions to be in bad faith, and I would ask the court to order civil sanctions for that. Thank you, Your Honor.
All right. Thank you, Ms. Moore. I'm just going to take a moment just to pull up that 2609-140. Just give me a moment.
Thank you.
Thank you. All right. Ms. Powers, brief rebuttal.
Thank you, Your Honor. Just briefly, Ms. Stanley wants the court to believe that this has been a good co-parenting relationship and the parties have worked hard to get to a place like that. But what we're missing here is a very, very key concern that happened. We have Miss Stanley holding all of this information about how Ireland has been in danger the last year, and she did not share that information until May. We have Miss Stanley discovering last summer this very concerning internet search, and it may have been reasonable for her to accept that there was some pornography problems going on, but we don't have any information that she followed up to make sure Mr. Mortensen was getting treatment and help to make sure that that was being addressed. We have in January, she leaves the kids for a week with Mr. Mortensen while she goes to Mexico. In February, we have Miss Stanley discovering the videos and photos that had been taken. The police reports explain that some of those videos were taken while Miss Stanley was present in the home, and yet Miss Stanley doesn't share that information with Mr. Gallagher or with law enforcement until May 22nd. She lets Mr. Mortensen live in the home. I appreciate that she says Mr. Mortensen was never left alone with them after her discovery in February, but that's kidding herself if she thinks she can keep those kids 100% protected with Mr. Mortensen in the home. She knew some of those videos were taken while he was present, and yet she still let him be there. We have one fiance, Mr. Gunnels. That relationship ends with a 99-year protection order protecting the kids from him. Now we've got relationship number 2 with Mr. Mortensen that ends with him having 5 charges for criminal conduct against Ireland and a criminal no contact order. We have Miss Stanley making the choices to bring these men into their kids' lives, and very recently held the information about what had occurred to Ireland, did not protect Ireland, did not communicate that to Mr. Gallagher. That was all very fresh. This all just came to light at the end of May. Then, by the time the kids go to Mr. Gallagher mid-June, Ireland has become aware of everything that's happened. About a month has gone by and she's not in counseling. We assert that this was an emergency situation. Our declarations explain that Sawyer was concerned about running into these men in Cle Elum. Cle Elum is a very small town. We have 2 relationships, both ended with protection orders, and now we've got these criminal charges. We've got Ireland in distress who needs immediate help. We believe that these filings were appropriate, that there was a reasonable basis here. We've provided a lot of evidence, and we ask the court to find adequate cause. Thank you.
Right, thank you. Right, so here we're on a motion for adequate cause to modify the parenting plans if there is a substantial change in one of the parties or the relationship with the children or what have you, warranting a modification of the parenting plan. So looking at what's happened here, the first thing that comes to light is Mr. Gunnels and the protection order that was entered against him, protecting the mother and basically keeping him away from the children as part of that order. Or the effect of that order. And then we have the issue related to Mr. Mortensen and the photos and the criminal charges related to the daughter. So one could look at this in a couple of different ways. And the way I look at it is that it's not necessarily a pattern that's present. It's maybe an emerging set of facts that suggests a pattern exists. In that there's these 2, which appear to be the successive boyfriends or love interests of Ms. Stanley that have necessitated the intervention of law enforcement or civil orders to keep the family safe from these men that Ms. Stanley has invited into the home. This is kind of it's a tricky situation because often society tends to blame parents for the actions of others, which is always is challenging. Here, obviously, Mr. Mortensen did what he did, or is alleged to do what he did. And that somehow that sheds a negative light upon Ms. Stanley. I guess, the old adage of birds of a feather could apply, but not necessarily. So I think that's the concern here, is that not necessarily that there's a pattern, but maybe there's a two relationships that suggest a pattern, maybe a pattern of choosing men that are not necessarily safe towards children. I think it's particularly concerning with Ireland when there's the incident in the summer of 2023 where the search history shows effing my stepdaughter. Obviously that's concern. Obviously there are algorithms that are tailored to our individual browsing habits. And sometimes those suggestions are pre-populated and come up. Is it possible that there's an inadvertent pop-up? Certainly. Is it possible that he had some prurient interest in the stepdaughter? That's also a possibility. So at that point, even with a reasonable explanation, I think a reasonable parent would have their radar tuned in quite intently to anything that would be happening with their child and that love interest that's residing in the same home. Ms. Stanley's response to when she became aware of the photos that Mr. Mortensen has allegedly taken of the daughter. I think that was a difficult position to be placed in by virtue of his actions. One, she wants to protect her child, and two, apparently she loves this man, and there's concern that he's threatening suicide. There's no perfect answer in that situation. However, there seems to be a greater duty upon parents to protect children who are not in as good a position as adults to protect themselves. So there's that occurs in February. And then to my surprise, Mr. Mortensen stays within the home during that period of time. To me, that's surprising. Surprising that a parent would find that their paramour took pictures of their naked daughter in the bedroom or in the bathroom of the home, and still allows for that individual to remain in the home. That's, to me, it's almost shocking. It's more than surprising. So there's that, and then these new allegations related to Sawyer, which there's not a lot of detail to that, other than that there are some allegations of maltreatment by both of those love interests of Ms. Stanley. Then we have the concerns about attendance and the fourth grade being a difficult year, and there's a lot of reasons for that: the death of the grandparent and the ADHD coming into greater focus, and then the absences, and then the improvement from in fifth grade. So I think all that that creates that suggestion of a pattern of choice of men, bringing them into the home of Ms. Stanley, that is sufficient to support an adequate cause finding. So I'll make that finding of adequate cause for modification of the parenting plan. The next step in looking at that after that adequate cause is that there's a request that the children remain with Mr. Gallagher. And then also in conjunction with that, there's a request for an appointment of a family court investigator to make a quick turnaround time investigation and report back to the court related to next steps. So at this point, I'm going to let the parenting plan that's in place take effect and run its course. So it sounds like the summer vacation period time is probably for Mr. Gallagher's probably has expired or run its course, and then the children should be going back to the mother's home. And why I say that seems to be reasonable to me, in that there's a 99-year order preventing Mr. Gunnels from approaching or being around the family, and then also there's a no contact order related to the family and also the daughter Ireland. So with the phone call, hopefully there can be safety and protection related to that. So I will appoint Jennifer Schaefer to do a very quick turnaround time and then come back to court on the 20th of August. And hopefully Ms. Moore and Ms. Powers, you're available on August 20th, Tuesday at 9 a.m. for a hearing related to her report and input.
Your Honor, if I may, I believe the court was going to address the order, the request to move venue to Kittitas County, where all the evidence is located. And I think if that were the case, then we would need someone here to investigate the matter rather than someone in Cowlitz County.
Right. Yeah. And maybe what maybe I should have heard the argument from the parties, but, after reading the briefing and the declarations from the parties, and having made that adequate cause finding, that I'm denying the motion to change venue. Notwithstanding that there's indications that it may be a more convenient forum as far as medical records and the like in Kittitas versus Cowlitz. So at this point, I'm gonna deny that request. And then as far as the August 20th review date, how does that look for the parties?
I'm sorry, I didn't mean to speak over Ms. Powers. I am not available that day, Your Honor. I'm scheduled for trial in another matter.
Okay.
No, I apologize. Not scheduled for trial that day, but I'm not available. Would the 27th work?
Ms. Powers?
Your Honor, my concern is that school starts on August 28th here. Would the court be willing to put this on your pro se docket on August 21st, if that works better for Ms. Moore?
Let me see. I can do the 21st, Your Honor.
Okay. Yeah, if that works for everybody, let's do that. We'll set the review for August 21, and that'll be on that 9 o'clock docket. That's accessible via Zoom also. So we'll set that for that review, and Ms. Schaefer will get that report out to the parties, hopefully prior to that court date, so that they can be prepared. I was going to just mention one other item. Oh, the request for attorney fees. I'm going to reserve on that at this point. We can address that again on the 21st. I just want a little more time to think about that, but at this point, I'll reserve on it. And then there's a request that Ms. Stanley made for makeup time. I think at this point, I'm going to deny that request. I think the allegations are of concern, of significant enough concern that I'm going to hold off on that and deny that request at this point.
Thank you, Your Honor.
Then, so I'll prepare that order appointing. I'll get a copy out to both counsel later today, if not tomorrow morning, and I'll just email it to you so you have a scanned copy of it. Any other items to address prior to us coming back on August 21?
I can draft an order that just reflects your rulings to be presented on August 21st. It'll be a pretty interim order.
Okay. All right, that would be fine. And then you could present that and send a copy to Ms. Moore. If she has any concerns, she can express those disagreements on the 21st.
Okay.
I just want to clarify, Your Honor. I'm hearing Ms. Powers say that she wants to draft an order reflecting your rulings, but since the children are being returned, I think that we need something today that indicates the restraining order is no longer in effect.
Ms. Powers?
The restraining order expired today. On the face of the order, I'm not opposed if the court wants to do a bench order. Basically, the order I was going to draft would basically just say the kids returned to mom, and then we've got this follow-up hearing August 21st. Attorney fees are reserved, and court denies change of venue.
So with the temporary restraining order that was entered on July 24th, sometimes it's helpful just to have a separate order that just clarifies that order has now ended and is no longer in effect. So I can do a bench order to that.
I'd appreciate it, Your Honor. Thank you very much.
Okay, so let me just take a moment just to write that out and then review the language with you so you all feel comfortable with that.
Thank you. Would the court be willing to include in the order that Ms. Stanley not have any third parties or men staying at the home or present during her summertime between now and the next hearing?
We would object to that being included, Your Honor. Ms. Powers did not present any argument to that. That wasn't part of her motion, and I don't think it's appropriate to now make that part of the orders. I believe that Ms. Stanley, who has been present the entire hearing, has understood the court's concerns and will act accordingly.
Ms. Powers, in your pleadings, as far as you made an oral request in argument today about no new romantic interest exposure for the next 12 months, was that in any of your pleadings?
It was, Your Honor. It was both in our proposed parenting plan, and I believe it was also in our declarations.
Okay. That motion is well taken, so I'll include that. Okay, so the immediate restraining order ex parte issued on July 24th, 2024 is hereby ended, terminated, run its course. Help me with some language here.
Expired or terminated sounds fine to me.
Okay. I'll use the term terminated as of the date of this order. And then the inclusion of the no romantic interest and exposure of the same to the children, would that be included in the order that you're preparing, Ms. Powers, or in this
I'd ask that it be in this bench order so that it's really clear that it applies for the next 2 weeks.
Okay. Ms. Moore?
Well, again, I think Ms. Stanley has heard the court's concerns. I don't know that it needs to be part of the bench order. Ms. Powers is drafting the order. I think that's sufficient. I'll vouch for my client that I'll talk to her after the hearing to ensure that she understands, but I don't think it's necessary to make it part of the bench order. I think the restraining order, the clarity regarding its expiration is what we really need at this point.
Okay, thank you. All right, bear with me one moment. Okay, so the bench order says the immediate restraining order ex parte issued on July 24, 2024 is hereby terminated as of the date of this order. Ms. Stanley shall not expose the children to any of her romantic interests until the court gives further orders and or direction at the hearing on August 21st, 2024 at 9 a.m. So that's the order, bench order that I'll draft, and then we will see everybody back here on August 21st at 9 a.m.
Thank you, Your Honor. If you would like to indicate my approval virtually, I'm fine with that.
Okay, great. Yeah, we can do that on that bench order. Thank you.
Thank you, Your Honor. Have a good day.
All right, that'll conclude the matter. Thanks.
Thank you.
Great, thank you. So we're on today for a presentation from the adequate cause hearing for modification on the parenting plan, and also then to take a look at the report from the family court investigator, Ms. Schaefer. So let's maybe, if we could please start with the adequate cause, the presentation on that. So let me just get that for me, and I'll hear, it looks like Ms. Powers drafted the proposed order. And I'll ask Ms. Moore, do you have any objections to the proposed order?
I do have one objection, Your Honor. I don't believe the court stated that Ms. Stanley did not file a response to the adequate cause petition. We did in fact file a response. Other than that, I don't see anything, have any issues with what Ms. Powers has drafted.
Okay, where is that concern related to the filing in the proposed order?
Just one moment, Your Honor. I'll pull it. I may have misread, Your Honor.
Okay, because I'm looking over that order. It's a fairly short order, and I don't see any reference to a non-filing reference.
My apologies. I obviously misconstrued something that I read in that. So we don't have any issues with the order as proposed.
Okay, great, thank you. So I've signed off on that, on the adequate cause order, that's signed. And then we're also here on, looks like Ms. Schaefer filed her report. This is dated the 19th of August, and so it's fairly fresh off the presses, if you will. And she makes some recommendations. I don't know if we take any action on those at this point, since it's fairly fresh, or if the parties wanted to have an opportunity to chime in with either agreement or disagreement with those recommendations. So I'll hear from the parties.
Your Honor, I would ask that the court make a temporary parenting plan today. The kids are supposed to start school next week, and we need some direction on where the kids are starting. We have reviewed the court investigator's report, and we are in agreement with her recommendations and would like to move forward.
Okay, and I think the parties did address that. I mean, I think there was previously that there were some concerns related to that, but so thanks for refreshing my memory about the school issue. Ms. Moore.
Thank you, Your Honor. We would like an opportunity just to respond. I wonder if the court has had an opportunity to read Ms. Stanley's reply declaration that we filed yesterday.
Yep, I read it.
Okay, thank you, Your Honor. We do have a couple of concerns about the FCI's report and her recommendation. So if the court is willing to hear that, we'd like to speak on those issues.
Yeah, that's fine. We can go ahead. That, you know, in short, I hear the recommendations from Ms. Schaefer, and this will kind of just serve as a lead off or a springboard for respective comments. There's a recommendation that the children attends the school, the 2024-2025 school year with father. The mother would have the first, third, and fifth holiday or weekends, pardon me. Holidays wouldn't change from the prior order. That there be a victim of a domestic violence class taken by the mother. Counseling continue for both children. That there be no male adult friends or significant others around the children for a period of 12 months. And details of court, don't share that with the kids. As, I put down especially dad. And then drug testing provisions remain for the father. So that's kind of the recommendations. I'll hear from Ms. Moore.
Thank you, Your Honor. We're asking, first of all, that the court make a temporary plan. We don't think it's appropriate at this time, as the court has already noted. We're sort of early days, so we're not at the point where we would be completely modifying the parenting plan and changing it on a permanent basis. We believe it's important for the children to continue counseling, so we agree with that, especially given Mr. Gallagher's actions in exposing the children to the finest details of the case. We have no objection at all to the children being in Kelso for the fall semester. Ms. Stanley's concern is she doesn't want the children to feel that they're going to be in Kelso forever and that they don't have the option to come back to Cle Elum. Ordinarily, I would not ask the court to do this, but I think the children need to be informed that they can go back to Cle Elum if they want to, because they've already been involved in the case. They've already been asked to make choices. We just want them to know that they're not stuck with a choice and that it doesn't reflect at all on their feelings for either parent. We think both parents love the children and the children love both of their parents. So we don't think that's an issue at all. We do have some concern about the suggestion that Ms. Stanley not have any male friends, adult male friends around while the children are with her. This seems to me to be an unwarranted restriction, and I believe we would need more information in order for the court to say this is needed and how, and that it's narrowly tailored to achieve a specific interest. I don't see that here. I would also mention, and I know you saw this in the declaration, Mr. Gallagher's wife has 2 teenage boys, one of whom lives in the home. If Ireland is having issues with adult males, it's not going to be specific to Cle Elum. There's not something special about Cle Elum. If she's uncomfortable around men, that's going to be something that's universal for her. And and I tell the court, I'm an adult survivor of childhood abuse. And so if you have discomfort, it's going to be with the entire population. It's not just going to be in one specific place based on my experience. If the court is any way considering this, we would ask that no other males be allowed around the kids when they're at dad's too. We're also asking the court to address the issue of attorney's fees. I know the court has reserved on that thus far. At this point, we have expended over 50 hours on Ms. Stanley's behalf. As the worksheets that Mr. Gallagher submitted show, he makes significantly more than Ms. Stanley, and this case has put her in financial hardship. I would like the court to also be aware, although it's not directly pertinent to making that decision, he's only been paying $1,000 a month in child support. Based just on the presumptive schedule, he would be paying over $2,000 a month. And if I had represented Ms. Stanley when this came up, I would have asked the court to exceed the presumptive amount, because this leads to a disparity between the standard of living for the children in both homes. So we would ask the court to award attorney fees to Ms. Stanley, and we're happy to provide any documentation that the court would like to see for that. Thank you, Your Honor.
Very good. Thank you, Ms. Moore. Ms. Powers?
Thank you, Your Honor. Just briefly in response, I want to make sure that the court recognizes, this was highlighted in the court investigator's report. When we were in front of you last 2 weeks ago, the court said we were reverting back to the original parenting plan, which would have put the kids with mom for the last 2 weeks. The court also put in a provision that mom would have no romantic interests around the children during her time with the kids. Despite your order, Ms. Stanley only chose to take the kids for 1 weekend. This was not communicated to us ahead of time. We didn't become aware that that was her plan until Mr. Gallagher had dropped the kids off for visitation. During that 1 weekend with the kids, she chose to take them boating with 2 single men. Ireland came back from the visit very upset. There's been a lot of allegations from Ms. Stanley that my client is inappropriately talking to the kids. He was not questioning the kids about this visit. Ireland came home upset and on her own told Mr. Gallagher what had occurred, that they had been on this boating trip. We believe that boating trip violated the court's order. We don't understand why Ms. Stanley didn't take those 2 weeks, but we are really concerned here that she seems to prioritize men in her life over these kids. At this point, we are asking the court to adopt the court investigator's report. I also want to touch briefly, Ms. Moore indicated that the kids have been put in a position where they think they get to make a choice and have been asked to make choices. That is not the case. The adults in this situation have brought this before the court to make a decision. It is my understanding that Mr. Gallagher has not put the kids in a position where they think they have the ability to decide where they are and what they do. Mr. Gallagher has reviewed the court investigator report. He agrees that nobody should be talking to the children, and he has been doing the best he can to juggle the fact that we've got a 14-year-old here. I think everybody's ignored that. Ireland is 14 years old, and as a 14-year-old, she is taking in observations on her own of the world around her, and she's drawing conclusions. And she has just been the victim of a crime where her privacy has been violated horribly, and she is working on processing that. Some of the things she's saying could just be because she's observed this and is trying to put all these pieces together. I don't think it's fair to allege that anything Ireland says means that Mr. Gallagher has talked to her inappropriately. So I'd ask the court to take that into consideration. I'd also point out to the court that we have asked for a restriction for males around Miss Stanley and the kids because the history has shown that the men Miss Stanley has had around the kids has abused the children. We've got the situation with Ireland, who's been a clear victim, but the court investigator report and also our declarations indicate that Sawyer has also been a victim of these men. This is not a restriction that needs to be applied to Mr. Gallagher because there's been no evidence to suggest Mr. Gallagher has had men around the children that are harmful to them. Ms. Stanley, in her reply declaration that was just filed this week, makes some pretty low blows about some family drama that happened historically in the Gallagher household. We have not had an opportunity to respond to that, but I would say that we don't even need to respond to it. It's not relevant to the issues before the court. What we have before the court is evidence that the kids were injured because of Miss Stanley's choices in males. We have the court making an order 2 weeks ago that she not have romantic interests around the kids. We have her exercising only 2 out of 14 days that she could have exercised. And in those 2 days, she brings them around 2 single males on a boat where people would presumptively be wearing swimsuits when we've got Ireland just healing from violation of her privacy. No wonder Ireland was upset after this occurred. The stepbrothers have been in the picture for several years. There have been no allegations of anything inappropriate. Mr. Gallagher's home has been a safe place for the children. We ask the court not to impose any restrictions around these stepchildren. And we do ask the court to enter temporary orders, adopt the investigator's report, and then also briefly in terms of child support and attorney fees, Ms. Stanley has not filed a financial declaration. She has not filed any pay stubs or income tax returns. Yes, Mr. Gallagher makes a significant amount of money. We have no information about the income in Ms. Stanley's household. It is not appropriate for the court to order attorney fees just based on the fact that one client makes a lot of money when we have no information about the financial status of the other parent. Additionally, we are asking the court to stop the father's child support obligation going forward if the kids remain with Mr. Gallagher. We are not asking the court to establish a child support obligation against Ms. Stanley. Mr. Gallagher does have sufficient in his household to support the children. And lastly, we're asking the court to appoint a GAL, and Mr. Gallagher is willing to cover 100% of the cost of that GAL. Thank you.
Your Honor, may I respond just briefly, please?
Yeah, that's fine.
Thank you. I appreciate the irony in Mr. Gallagher continuing to talk about Ms. Stanley's choices in men, especially since he was one of them. And it should not be discounted that during the divorce, he had supervised visits because he himself was harmful to the children. And the people that were on the boat were just friends. They weren't romantic interests. It seems that Mr. Gallagher is just trying to drum up more things against my client. There isn't an allegation that he's talking to the children about the case. That's actually a fact. And the family court investigator noted that in her report and also made it part of her recommendations. So I don't think it's possible for us to really believe as rational, reasonable people that this occurred and the children haven't been influenced at all. And I wanted to be clear. I apologize to Ms. Powers because there was apparently a miscommunication on my part. Ms. Stanley was concerned with the way that all of this occurred this summer with Mr. Gallagher's actions. She didn't want to upset the children by suddenly changing the visitation. And so what she had suggested was, let me take them for the weekend. We'll just have a visit. Then they can go back to dad's until we've had a chance to go back to court and see what the judge says. So for her, that was about doing what's in the children's best interest, not because she's out gallivanting with men. And I quite frankly object to that characterization. It's inappropriate. So we're asking that we don't have a problem with the children being enrolled in Kelso. We think that's appropriate. We want to be able to revisit it for the spring semester and see where the children are going. And we're just asking that restriction for all male friends either apply to both parents or neither. Thank you, Your Honor.
Thanks, Ms. Moore. Ms. Schaefer, do you have any comments you'd like to highlight?
Yes, Your Honor. Unfortunately, I didn't receive a copy of Mom's response, so I'm just going to try to address some of the things Ms. Moore brought up. I don't think it's a good idea to reevaluate the children in the middle of the school year. I think they should be able to complete the entire school year. I think it would be in their best interest to be able to continue the whole entire time instead of having to transition maybe back to the school if that's their choice. I do believe that they should have a choice if they don't like the school. My second concern is with the males for mom. I would like for it to specifically be for mom. I do feel that mom made a couple poor choices in the last couple of weeks with allowing the first gentleman, Travis, to stay longer than he should have. And then when she does get them back, it's more about having fun with the kids. And she did put Ireland in an unfortunate circumstance on that boat and made her uncomfortable. I don't think her forethought was about Ireland and what she has gone through and how to help her heal. And so that's my concern with the other male friends being around mom.
Thank you, Ms. Schaefer. Okay, so related to the temporary parenting plan going forward and the need for some direction with the school year starting here soon. So kind of the basis of this, let me just start with the adult male issue that seemed to gather quite a bit of airtime. The court did order on August 6th that Ms. Stanley not expose the children to any of her romantic interests until the court gives further orders, which would be today. So, language is squishy. Language is sometimes imprecise. When you say romantic interest, that may very well be hard to quantify and measure. What we do know is in the past, Ms. Stanley has chosen two men whose the relationships with each of them has resulted in either a restraining order, a prohibition order, or a no contact order, preventing them from having contact with either her or the children or both. So I'll just make mention to the parties that are in the courtroom here today that even really quite hushed whispers, there's something about the human brain when they hear the human voice speaking. I hear it and it distracts me. So please don't whisper. Mr. Vorst, please don't whisper. So I was just saying that the human mind is attuned to hear human voices, and the acoustics are good in this room in a way, kind of bad in a way, in another way. But when people are whispering, I hear you and it's distracting. So I appreciate, if you need to converse, please go outside. So with regard to those two companions, there were resulted in no contact orders, which subsequent to that, there was an opportunity to go boating. And in context, I can see where Ms. Stanley said that might be fun for the kids. And I can see where that may be very tone deaf to the situation of a young lady whose privacy has been obliterated. So it's, there's concerns there. So while Ms. Stanley indicates in her reply declaration that they're not romantic interests, friendships begin in all kinds of different ways. So I think the prohibition of having any adult male around the children is appropriate for a period of 1 year, and it applies simply and solely to Ms. Stanley. And the issue with the stepbrothers, there's been no issues raised related to the stepbrothers. And again, I think there's a distinction there, category-wise. The adult men that were brought into the home were adult men of significant older age, where the other stepbrothers are much closer in age to her, and our minors are just passed through the minor phase. So with regard to the school, I'm going to order that the children attend locally in the Cowlitz County, which I think is the Kelso School District, for the school year 2024 through 2025. And I think that's important to have that continuity, that it not be addressed. It'll be for the full school year. Mother will have the first and third and fifth weekends as presented and recommended by the family court investigator. I do think it's important that there be a little more education, maybe some of that tone deafness that I spoke of with education, and maybe exposure to different ideas and playing with those ideas and working through some of those issues would be of assistance to Ms. Stanley. So I'm going to order that she sign up and complete a victim of domestic violence class, because I think that she has been victimized in some shape and form. Counseling, it sounds like both parties are agreed that the children will continue to do that, and I appreciate everybody supporting them. I think it goes without saying that both parties are prohibited from discussing adult issues, meaning court issues with the children. I recognize that tends to be a very hard thing to do, especially when you have a 14-year-old. 14-year-olds are pretty keen and perceptive, and it's hard not to talk about those things. What happens when you do talk about those things with children? Children take ownership of those items, and that they feel that they have some control over the situation. And when things don't go that way, they want to please both parents desperately. Desperately, they want to please both parents. And if when they do one thing or another, they take upon themselves unneeded stress and anxiety and responsibility. So please, 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 just let them know the judge says I can't talk to you about it. Put the blame on me. So the issue of the drug testing, those provisions still remain. That's fine. Attorney fees, I'm going to reserve on that, as I indicated before. The reason we're here are due to decisions made by Ms. Stanley. And that led to a motion for adequate cause and a modification or granting of an adequate cause order and a change in the parenting plan. In addition to that, the financial waters are not terribly clear, at least in my mind. Once the children are returned to the father, then his child support obligation would cease at that point. And I will grant the motion for appointment of a guardian ad litem with Mr. Gallagher covering the cost 100% for that appointment. We need to talk about who that person would be. We have 3 individuals that are primed up on the list. And if we want to proceed in that fashion, I could have the clerk say those 3 names, and then you could exercise a strike if you so choose.
Yes, please.
All right.
Your Honor, we'd like an opportunity, because I'm not in Cowlitz County normally, I'd like an opportunity to be able to find out some information about the GALs, if the court would allow that.
Sure. And let me just ask kind of your approach on that. Generally in court, I would present 3 individuals that would be next on the list. I guess we could present those 3 names and then kind of reserve that in time and space and then come back in a week or so, and if there's an exercise any strikes based on those three names. Are you okay with that, Ms. Moore?
Yes,
Powers?
Your Honor, I'm fine with that. Normally, how we handle it when the parties are represented in the other counties where I appear is the attorneys just talk and come to agreement on a GAL, and I'm sure that Ms. Powers and I can do that.
Your Honor, I'd ask that you give the next three names and I be able to put my strike on the record, and then Ms. Moore can report either to the court or email to the clerk and I within the next 3 days if she's striking one of the names.
That might be just as efficient rather than having to come back. That I'll present the names. That way Ms. Moore knows who those names are and she has the opportunity to do some research and find out a bit more about each of those individuals. I'm fine with Ms. Powers exercising a strike today, and Ms. Moore can exercise a strike sometime prior to next Wednesday. I'll give you a week to look at it. Because that 3 days is a pretty quick turnaround time if you're not from the area. So,
and also I'm out of the office for a few days too.
All right. So by next Wednesday. So let's hear those three names and we'll go from there.
We have Karen Lawrence, Heather Call, Beth Fellows.
Okay.
I will strike Beth Fellows.
Okay, Ms. Fellows is stricken. So then the two remaining are Karen Lawrence and Heather Call. Heather's Call spells her last name Kahl. And Karen is Karen and Lawrence Lawrence.
Thank you, Your Honor. And Call again was Kahl.
Yep.
Yes. Thank you.
Yes. All right. So what I'd ask the party, so this doesn't get lost in the shuffle, the attorneys are going to communicate with each other as to whether Ms. Moore will have a strike. If there is no strike, then the next person on the list, which would be Karen Lawrence, would serve. If Ms. Moore strikes say she strikes Ms. Lawrence, then it'd be Ms. Call. If she strikes Ms. Call, then it would be Ms. Lawrence as the appointed person, as the guardian ad litem. So if the parties, once you've communicated with each other, if you could just forward a copy to myself with just a little reminder, a tickler file, say, Judge, this is the guardian ad litem. Please either sign off on this proposed guardian ad litem order, or that would be my preference. If the parties, once you've come to who that person is going to be, if you could just forward the proposed guardian order appointing guardian to me, and then I can sign off on it.
Your Honor, could I propose a different solution?
Sure.
Could we just set this for presentation next Wednesday? I'll have the GAL order already, except I won't have the GAL name written in. And then when we appear for presentation, the court can write in whichever name. Because we still need to enter the temporary parenting plan and other orders.
There's more.
I'm sorry, I didn't mean to talk over anybody. I am not available next week. I'm just looking, today's the 21st. I'm not available through Wednesday of next week. And
Could we put it on your presentation docket Friday the 30th at 8:45?
See, let me check my calendar.
I can do that, Your Honor.
Yep, that works. We'll set it for presentation August 30th at 8:45 in the morning, and parties can appear via Zoom, and any proposed orders, you can just forward those to me via email.
Thank you.
Thank you, Your Honor.
Okay, thank you much. We'll see everybody on August 30th, 8:45.
That matter's ready. But for the record, I'm Chelsea Baldwin and I represent Mr. Gavino, and we're the moving party today. We have two motions to address. One is a motion for contempt, and the second is a motion for relief. I'll just address the contempt first, and then my argument will just essentially then move straight into the request for relief. So in this case, the contempt is specifically about the mother's failure to obtain domestic violence counseling as ordered in the April 2023 order, as well as restrictions regarding introducing new parties or new significant others prior to that relationship being stable for 9 months. The first issue is the domestic violence counseling. At our filing, there was no evidence whatsoever that she had done anything associated with that domestic violence counseling. On reply, what they provided you with was a single sheet of paper that essentially purports to come from a treatment provider, but in no way says she's received counseling. And I think the court should be very careful to look at it and look at what it actually says. Essentially, it says that there's been 2 intakes, and then it says she said this at the intake. So it's essentially just regurgitating what the mother wrote onto the form for the purposes of the intake. And the provider says, well, she's on my caseload, but she never says that she has seen her, nor had a single session with her. There is no, hey, this person has seen me this date, and this date. There's none of that. And I believe that's because it has not happened, that no counseling has ever actually occurred. And this counselor trying to appease their client and write this statement sort of in their favor, but being very careful to parse their words to not be untrue. So here what we have is a statement that in no way shows that she's actually done counseling, simply that she's done an intake. It's been more than a year. That's contempt. My client was ordered to do a couple things. The mother was ordered to do a couple things. My client's completed all of the things he was requested to do. And mother just says, I'm just not going to do it. The second issue is introducing new partners. We have two specific instances my client talks about around the 4th of July holiday, as well as a wrestling match of the children, where it was actually my client's time. Mrs. says, hey, I want to take the kids, but you can't come because it's restricted. And then later it's actually the boyfriend went with her with the children. So again, introducing these new partners prior to the 9 months being up. The response is essentially, well, I shouldn't be in trouble. I'm going to raise these issues of domestic violence, and therefore that should just sort of cover what I did. The court has to be cognizant of the fact that in the final underlying, this is a modification action we're on now, in the underlying final orders entered in 2015, there's no domestic violence pled whatsoever, no domestic violence found, no restraining orders, no 191 factors. And even that letter from the counselor is actually sort of a piece of evidence in our favor, because the intake that was reported to have been done in February of 2023, so before the court ordered her to get counseling, says she didn't need treatment for her claimed mental health due to abuse. And now she's saying, oh, I'm so injured from the abuse that I need treatment. But actually the counselor's report says something different. It says she did an intake and didn't need anything back in February of 2023. So essentially 8 years later, 8 years after that original 2015 order was when we file our motion for modification, oh, we're going to claim domestic violence. So it's really raised here in association with the contempt, because it has nothing to do with the contempt whatsoever. It's only raised as a scapegoat. Because essentially, hey, I shouldn't be held in contempt because he's a bad person, and here's what I'm going to say, even though, again, long history of no domestic violence. I'll note that my client was required to do a domestic violence evaluation and any required treatment. If you look at his evaluation, it's essentially 0 on every single score. It's essentially like, nope, not a risk, not a risk, not a risk, not a risk. And when you get to why he was ordered to do treatment, it was Mrs. said that they yelled at each other, and therefore I'm finding. There's no prior findings. It ignores, in fact, the prior findings that were contrary to domestic violence. And I'll tell the court, in almost 20 years now, I've never seen a evaluation come back that didn't require treatment. These are the same people that do the evaluation, that do the treatment. And so it's a sort of self-fulfilling prophecy. If you send someone for one of these evaluations, they're going to be found to be required to do it across the board. So my client gets this very low score, and they say, well, in an abundance of caution, we're going to make him do this minimal treatment, which my client then does. He doesn't stick his nose up at it, doesn't say I'm going to refuse. He still does what he's supposed to do. So again, really just a red herring, and just trying to defeat the contempt by saying he's a bad guy. In this case, the court should find contempt for both of the reasons alleged. We're asking for $3,500 in fees, $100 in costs, and a $500 civil penalty. Next, I'm turning to the motion for relief. The underlying plan was essentially a 50-50 plan, and we're asking the modification action that's pending now is the father's request to modify that off of the 50-50 plan. When you look at the motion itself, it's very pointed and very directed at children's needs and the efforts to obtain care and necessary care for these children. The first request is essentially to maintain counseling for the child and to not switch the counselor yet again, that the children not have contact with an offender and an alleged abuser, that she be required to comply with the orders, that the children's school be based on the father's address, again, to remove the children from potential triggers and potential abusers at their school, and to adopt the father's parenting plan. These children are in absolute crisis, and unless we step in and change the plan, it will continue to worsen. There is no doubt that unfortunately, Kyson as a child is heading down the road to be a juvenile offender. And unless we take serious action, this is not going to be a local sanctions problem. This is what he's headed towards is extremely, extremely dangerous. And Kyson is still a young child. This is not a teenager. This is still a young child. So in this case, when we look specifically at Kyson, the mother has avoided, obstructed, and denied and delayed care. She's used joint decision-making as a sword and not a shield to say, no, I refuse to continue any care for child, to the point that the school stepped in and mandated care. So the school essentially mandated treatment because the child's actions were that disruptive in school. The child's counselor says, hey, child needs treatment. My client says, I'll pay 100%. So there's no barriers whatsoever to maintaining treatment. Mom says, no, Nope. Instead, I'm going to, only when pushed, only months later, I'll schedule an intake for a completely different person in a completely different facility, and we'll just start the cycle over. But really, I think the goal is to just, hopefully it just goes away and we never continue treatment. This is really par for the course. My client provided a significant amount of detail on the long-standing history of denials of care and refusals to allow Kyson and really both children to maintain care and maintain services with providers. It's essentially, once a provider starts saying something I don't like, well, now I'm going to switch providers and use joint decision-making again as that sword and not a shield to force that to happen. In this case, one of the alleged abusers is the mother's teenage brother, so still a minor, and that child admitted to showing pornography to the boys. And we would argue this is grooming behavior, but the children's underlying behavior is escalating, which indicates that the triggers or whatever's happening to the children has not stopped. When you look at the records that we provided from the school, and it's under Exhibit B of my client's declaration, it's a laundry list. I mean, it's not like one or two violations. It's violation after violation after violation. And they're 90% of them are sexual in nature. Specifically, if you look at, and these pages aren't dated or aren't numbered. Let's see, the 4th page of Exhibit B notes a violation. Kyson demonstrated a sexual act using 2 hands, quote, twisting a dick and putting it in their mouth, as he put it. And when he asked where this idea came from, he references that half-brother or of the mother. So again, showing these images to children. And this is not the only incident. These incidences progress, become so pervasive for the child, his behavior so out of line for especially, and I would say for any age, but I think more shocking for a child that's this age, that the school then has to do a threat assessment because Kyson is essentially injuring other children. That threat assessment is under Exhibit D. That threat assessment was completed mid-May of this year. And when we look at that threat assessment, the 2nd page of the threat assessment says the threat assessment team would encourage you to take this level 1 treatment plan seriously and to pursue each item listed as a must do. So they're saying this is a red flag. When we look at what they are specifically saying needs to happen, what the family needs to do, bolded as their bold point number 3, continue mental health counseling. So again, stop these breaks of mental health counseling. This child needs to be in mental health counseling. And that the 4th or 5th bullet point down, discontinue contact with Uncle Landon, with the child, with the person that showed them pornography originally. And then has some other recommendations and to continue to allow contact between the provider and the child's school. So again, we have a child who cannot control himself, whose behaviors are escalating, who the school has to do a threat assessment on, and the school is saying, this is very bad, you need to take action. And what does mother do? This is about the time that she moves out of her house and moves into a trailer at the same address. So essentially a trailer in the driveway where her mother and her brother, Uncle Landon, live. So now instead of them at least being separated by address, now we're even closer. So instead of the discontinue contact, we've brought these people closer together. So we have this relocation, and I would argue there are no indications that that trailer is hooked up to water and sewer. And like most residences do not have those types of hookups. So we have children that are bathing, showering, using the restroom, all in the main house where this person lives, where their alleged abuser lives. So, and the idea that the court had already ordered line of sight, the idea that that line of sight supervision is happening, I think is not to be believed. Every time a child has to use the restroom, you're not going to follow them across the driveway and into the house and make sure. And that's the problem, is that Landon has free access to these boys, and that's why you see escalating behavior. Mother next tries to say, well, really, if these children's at school's fault, and so we should blame them instead. But the adage is true that abused children abuse children. So we have a child who unfortunately has learned things he shouldn't have at this age and is now demonstrating that and creating a cycle of violence with other young people at his school. That's why Kyson has the threat assessment, not other children. But interestingly, my client says, then let's remove those children as part of the trigger, as part of that cycle of violence. And mom says, no, I'm going to use joint decision-making to say children can't switch schools. We can't remove Kyson away from sort of this negative environment that's been created. So again, repeatedly using decision-making as a sword and not a shield. So again, these are the children's behaviors are escalating. And what is mother's response to that? Not a single action plan for really the children or what should happen or how to prevent things from happening. No, she then once again returns to the same thing she filed more than a year ago. Dad's a bad dad, and therefore you should focus on that. claims that he misuses substances. But we actually did a formal substance abuse evaluation with collateral contact that found my client doesn't have any substance use issues whatsoever. Oh, well, domestic violence. And again, we've already talked about that. It's essentially no, essentially no on every question. These parties yelled at each other, abundance of caution, but my client did what he was supposed to do, completed that. Dad showed him a bad email, and because he showed him that email, that's how they learned about sex. My client was like, well, one of the kids wasn't even born on the date of that email, and the other child was 2. So unless these children are major sleuths and going back into an email that's a decade old, that doesn't make sense either. Whatsoever. What does make sense, what is logical, is these children are being left with Landon unsupervised, and he has access to these children, who he already admitted that as an older teenager, he showed hardcore pornography to. My client is pleading with the court. These children need help from an expert. They need to continue in care, and removing them from care and refusing to allow them to continue with the care that the school system said was absolutely critical is just negligent. It's abusive in and of itself. These children have to remain in care. Second, to remove Landon from having access to these children. There should be no access by that child whatsoever to these children. Remove them from the school, so the school that they're currently in, which doesn't match either parent's address, and place them where my client lives. And then similarly, to not allow the mother to disrupt treatment that is necessary, because that has been a consistent plan. My client is asking that we adopt his parenting plan that would move us off of a 50-50 plan. But at this time, it doesn't make sense that children who can live full-time with my client and have rooms in a home versus living in a trailer in the driveway with their abuser basically next door, that doesn't make any sense. And so placing them with my client is protective and appropriate. When you turn to the mother and what is her plea for the court? Her plea is don't do anything, just leave it as it is. We can't continue to allow the child to spiral and essentially put our heads in the sand. That is not effective and not reasonable. We do have an obligation to act. In this case, I have spoken to Mr. Zandy in advance, and I believe we have an agreement to have Mr. Keith Lawrence do an investigation into specifically essentially what's going on with Kyson and the sexual abuse that's happening for him. Mr. Lawrence does have a background in sort of those types of investigations, and so that's why we think he'd be best suited to be able to provide input, just because he's been around that role a significant amount of time and has more familiarity with some of the issues. But again, there is an obligation to act. We cannot just simply ignore and push this down the road. We have children that are at a critical point. And unless we act, we're going to be in a very different position. But unfortunately, I think it will not be in front of this court. I think it would be across the street.
Mr. Sandy.
Thank you, Your Honor. You represent the respondent, Madison Cook. We'll start with the easy issues first. I think that's the contempt. Again, if you look at the contempt, and I was somewhat surprised by counsel's statements that she found the letter from the counselor deficient. My client has been proactive in this. Letter states that, and just because it says that the word caseload is being analyzed, I'm not sure why. We have a caseload. Ms. Cook is on my caseload. That's how I would determine that, and I'm here in court representing her. If you look further on that, it states very specifically from the clinician, please accept this letter as a matter of compliance for Madison Cook. So she's done everything she could. This was clear back that she started with this counselor of this agency back at the first of the year. So why we're here now 7 months later is somewhat of a surprise to me. This could have and probably should have just been resolved with a quick phone call. Mr. Zandy, please get me what you can for the compliance, and I would have certainly done that. If you go further in that, delve a little bit deeper from the core health clinician, it states Ms. Cook expressed concerns regarding the need for a specific type of counsel for domestic violence. She was forthright and honest with that and has been clear back to 2023. The client articulated that she spent a considerable amount of time looking for a DV counselor with no positive results, and largely that's because they're used to dealing with perpetrators, not the victims of that. Again, my client got out in front of that, stated specifically that she needed some kind of assistance with that, and as the counselor states, that Ms. Cook came back to court help to receive trauma-informed counseling services. So again, I'm not sure what the information, it does give a timeline very specific, not sure what the information being proposed by Mr. Gavino is suggesting, but she's in compliance with that. Also interesting to point out, and again, this has been kind of the theme of this case going back to 2020, late 2022, early 2023. There has been significant amount of information filed about the DV impact that Mr. Gavino had on my client. That's irrefutable and again, undisputed. And I'll get to the GAO findings here momentarily. But nonetheless, he's putting her in this position. She's seeking the services, and then him as the perpetrator comes back and says, well, she's not doing what the court orders related to the position I put her in. Seemed extremely disingenuous to me. As it relates to the boiler, again, my client has given you information on that. There's no information provided by Mr. Gavino, and again, the court as well is aware the burden is on him to prove a willful and intentional violation of court order. He hasn't done that. As he's done since 2022, he comes before you today with wild speculation, paints a narrative and a story that basically fits his end goal, which is custody of these kids. And again, as an abuser, kind of keeping my client under his wrath, under his control, and under his thumb. Very similar with the boyfriend. My client details for you. They never started dating until I believe April of 2023. Kids have never been exposed to him except well prior to that. And again, that dovetails exactly what my client has kind of detailed, which is she's friends with this individual's sister. They've hung out in the past. She's been an acquaintance with this person, never in a dating relationship. The kids haven't seen him in a significant period of time. She did not expose the kids to this individual until the lapse of about 11 months by my count after she started dating him. There is no information that suggests that he was exposed to these kids, that they were ever around him. Do they know him? Yes, but that was from the past because, again, his sister, I believe her name was Carly, and my client are good friends. They've gone so far, and again, testing with my client. What does she detail for you? He said, I've gone so far as to keep these kids away from him, that knowing there was a 4th of July party, he went someplace else. I did my own thing, again, to abide by the court order. There's no evidence to dispute that. What he does say, and that being Mr. Gavino, is he makes these allegations, admits that the kids weren't, that start talking to this new individual are exposed until the spring of 2024. Again, which was March 17th by my client's statement, when she says, it's been 11 months, we're in a committed relationship, let's go on a bowling outing, and that's when the kids were first exposed to him. So again, I find the burden has not clearly been met. It's not really even close. There is no showing of willful and intentional violation by my client, and I think that's an easy one. I would also submit strategically, again, this appears to be in line with kind of what Mr. Gavino has done for the past several years. Make the allegation, use it to support whatever it is that the request that I want, and this just has zero merit from what I can see. We are asking you to deny the motion for contempt on both counts and consider what we've suggested, the $750 in fees and costs for responding to that. That's a simple issue, not much more complicated. These are the issues with Kaisa, and everybody agrees. And I've had discussions with my client, I've had discussions with Ms. Baldwin. This is a difficult one. And when I contemplated earlier and told the court, this is not one that leaves me envious of being a judge in this case, because this is difficult. Everybody knows something is going on with Kaisa. It's terrible. It needs to be fixed. But my client tells you what I'm suggesting is, instead of pointing fingers back and forth and throwing rocks over the bow, maybe as parents, they need to come together and figure out who the culprit is, what's going on with this kid, and put him on a path where we can resolve this issue. My client is willing to do that. Nothing Mr. Gavino has done up until this point suggests that he is. And again, that's the problem. As he's done from the very onset of this case, it's very easy. Again, it fits his narrative. It fits very succinctly and nicely into what he wants to see happen in his goal of this case, which is to assume custody of these kids. He blames Landon. We've detailed for you. The GAL has investigated that. There's no information. There's nothing that shows that Landon is any kind of a threat to these kids. In fact, just the opposite of that. If we look at the GAL findings, and again, I think they're pretty specific as it pertains to that. Ms. Turnbull states, quote, there is no evidence that Landon had any sexual contact with the boys, such as child molestation. She discusses that throughout. She goes on, and again, this is part of the issue of this too. It's easy to point the finger at the other side without looking in the mirror on this. What has Mr. Gavino done? Nothing. He simply states it's Landon's fault. Landon is the perpetrator. I need to take the kids so that they're not exposed to Landon. It's the same individual, and whether counsel articulates in her argument that, well, that was in the distant past. It's an individual who fails to recognize his choices related to this. It's an individual who solicited prostitutes, and again, that was information provided back in January of 2023 at the onset of this, in which he goes so far as to discuss prices, locations on a device that he knows the kids have access to. I don't care if they're 2 or 20, there's still an impact on that. This is the same individual who, not that long ago, but 8 or 9 months ago during one hearing, admitted, yeah, I didn't have very good child locks on any of the devices. It's referenced in the GAL report. They've had access probably to that. I need to hone that in a little bit and be a little bit more cognitive of what they're doing on those devices. It's the same individual. And again, there's very little response to this in reply. He just says, that never happened. Who spends his weekends with the kids and lets them go to these various third-party homes under the guise of a birthday or sleepover, whatever the case may be, doesn't inform my client. She's left in the dark, sends these kids to unknown places. My client, this is kind of telling this, gets a communication from one of the parents, Dre's mom, whoever that is, saying, I understand you're going to pick the kids up at noon today. My client has no idea what she's talking about. In reference, Mr. Gavino says their mother's going to pick them up. He means stepmom. Doesn't clarify that, leaves my client intentionally in the dark, leaves them at home with unknown people. In the message, we provide a copy of that for you. Says, don't worry, my 15-year-old's going to be here to make sure that the kids are supervised. That's concerning. My client details for you, and I don't think this is the same. I think this is a different incident in which she's informed that the kids, again, are going to a sleepover at a friend's house. She goes to the place, wants to see where the kids are, and tells you it's in deplorable condition. It resembles a flop house. There are unknown, it reeks of animal urine. There are unknown adults in the house, unknown children in the house. And basically, Mr. Gavino says, that's all right. You go to this parent's house or this person's house. We'll deal with it later. We'll just blame Landon. I am not suggesting, because I have no idea. I don't know who the perpetrator is. I don't know what's happened to Kyson. I am not in a position to say that. And that's the hard part as an attorney and representing my client. What I do know is as a parent, and this goes back to early school year 2023 into 2024, if my 8-year-old is having sexual problems, and those are exasperated over time to the end of the school year where it all blows up and things are completely off the rails, I am not going to expose that child to places where he could potentially be placed in harm. I am not going to place him in a situation where he could get in trouble or he could violate another child or vice versa. I'm not going to leave him with random people and not tell the mother of that child what's going on and make a joint decision. Again, this is a case where there's significant gamesmanship being played and nobody's recognizing the best interest of this kid. And that's sad. It's more, well, this will look better in court. This will look good in court. I'll make this allegation. This is what's happening. Let's take that to the court, as opposed to recognizing the problem and dealing with it as we would expect and hope that two good parents would do. This is the same guy who provided you a declaration from my client's mother, who's the mother of Landon, who says this is the same guy where she goes to a sporting event, he sticks his foot out and says, get out of my space, and tries to trip her as she's walking by. There's no response to that in his reply. This is the same individual who takes, my client has another child. Dad doesn't have any rights. What does Mr. Gavino do? Takes this individual, biological dad's mother, takes him to a game where the kids are going to be, tells the child who's not even his, oh, this is your grandma. Who does that? That's somebody who's playing games. That's somebody who's vindictive. That's somebody who's angry. And that is most certainly the actions of a domestic violence perpetrator. Back to Kyson, we need to fix this. We need to, instead of pointing fingers, figure out and hand this over to a professional so that he or she can deal with the best interest of this child and get to the bottom of it. We've given you significant information about what's happening here. The allegation that my client hasn't participated, that she's somehow dragging her feet when it comes to counseling, is not borne out by my client's declaration. It's certainly not borne out by the communications we've given you. My client has gone to great lengths to show you that she's communicated with Ms. Owens at CMAR. My client has told you that she's worked with the school, and Ms. Fike, I believe is the name, Dr. Conley, Charlotte Rosen. She's reached out to the Hope Project, Suzanne, the most recent counselor. She's gone to Core Health. She's looked into the WISE program. We provided you all that information. We provided you the communication she's had with the school since, I want to say November or December of last year when we started seeing these issues. And oh, by the way, these issues with Kyson didn't occur until almost a year and a half after this reported exposure to Landon accessing some kind of pornographic material on his phone when the kids walked into his bedroom. Got to beg the question, what's happened between that? And again, it's easy for him to point the finger at Landon. Between that elapse of time, but all of a sudden things with Kyson to just, again, go off the rails. We don't think it's Landon. We think it's some other third party. The fact that we're leaving these kids with random people at houses that are unknown, being watched by 15-year-olds who we know nothing about, given the fact that dad has admitted in the past that, well, yeah, I haven't monitored the kids' cell phone use or device use very good over recently. I need to fix that. Given the fact dad admittedly is propositioning prostitutes online, and I don't know if it was an email or what it was, some kind of message going back and forth on a device that's accessible by the kids. What confidence do we have, or how can we sit there and point the finger at Landon and say, it's the 16-year-old kid who doesn't have a voice for himself. It's the 16-year-old kid who's the perpetrator when dad's acting this way. The same guy, and counsel talks about some of the comments about drug abuse, and well, it's not a big deal, his test came back. You have the very information from not only Mr. Gavino, but his current wife, where they're talking about Las Vegas trips, snorting cocaine, drinking, having the time of their lives, and that wasn't that far back in history. Again, what confidence do we have to rely on anything he says when the GAL and this court in the most recent past has stated that a lot of what he alleged is unfounded or untrue? Again, I don't know if the court had the opportunity to look at a lot of the findings from Ms. Turnbull. Again, I told you about the incident with Landon and her findings on that. But it goes further than that. It states Mr. Gavino, despite not drinking or using marijuana currently, may have a problem with drugs or alcohol. And the collateral information she rests upon is his existing wife, stating, well, it kind of comes and goes in waves. That's pretty reliable information. She gives you this. The mother does have a history of domestic violence relationships, including her relationship with the petitioner. And again, this is from an unbiased third-party investigator, this court appointed. So if you look at the information, and again, you look at what the request is now, it's basically asking you to have trial on motion. And again, this is a case where we certainly need more information. He's asking, well, take the kids and put them in my school district. Again, that's a card that puts ultimately the ultimate determination in his favor. Well, appoint somebody that can come and investigate this, put the kids with me, let's put the crimps on Landon. Again, without recognizing what he's contributed and what he's brought to the table. And that's very concerning. And that's somebody who just is so concerned with pointing the finger at my client, at Landon, at other people, that he doesn't recognize the issues within society himself and the impact on these kids. I don't know. And I hope by the end of this, we can figure out what's going on with Kyson. I second my sentiment with counsel's comments, and I agree with her. I do not want this to turn into a case where this becomes criminal. I do not want this little guy to suffer any more than he potentially already has or is. It needs to stop. We need to get to the bottom of it. My client has done what she can with counselors. She's done what she can with the school. She's done all of that, and that's evidenced by all the information. As far as we need to use my counselor, no, we need to use my counselor. Mr. to say, well, I have tried to get him back into Suzanne. And my client saying, well, maybe we're beyond that. Maybe we need to look someplace else. He says, no, it's Suzanne or nothing, because he has some kind of inside information about everything. So again, detailed as a covenant not to compete clause within the counselor's contract. That's interesting. But the same parent who says, no, I'm not going to let or allow my kids to meet with school counselors outside of my presence. So you have this complete push-pull, fighting over counsel, fighting over medical services. The same person who the GAL tells you hadn't had any concern with counseling, didn't attend doctor's appointments, had no knowledge of the Adderall or ADHD with either kid until the verge in the 11th hour prior to him bringing this modification petition. It reeks of being disingenuous. It needs to stop. Now, these parties need to come together and figure out what is best for Kyson and stop with the back and forth. My client realizes that. She wants to get beyond that. She's tried to get beyond that, but we keep getting this wall put up by Mr. Davino, only to say, well, it's her fault. This isn't working. It's Landon's fault, without any kind of proof. We can't upset the apple cart right now because it's hard to come back from that. If we make major changes today, finding that some third party or something's happening at school or with one of his friends or with somebody outside of who we know, it's going to be hard to put that kid back into a place that's going to protect him. And he's got a brother Jameson as well. I mean, so you're dealing with two different issues, two different kids. My suggestion is we keep things where they are. I respect Ms. Turnbull. I think she's a good GAL. I think she certainly does what is expected of her and then some. If she's comfortable with this type of case, great. I did confer with the counsel. We did discuss Keith Lawrence. I know now Mr. Lawrence, with his background, is equipped to deal with these types of cases. Fine. We just want somebody to report and report back quickly as to what the preliminary findings are, what's happening with this child, and then we can make bigger decisions about school and about custody and about visitation and about limitations. There's already a limitation with Landon. My clients complied with that. They're not in the house alone with Landon. Landon's not alone in the trailer with them. Sure, they see each other in passing, but the court order is, again, no unsupervised, no third-party adult contact between the kids and Landon out of an abundance of caution. And you have the information from the GAL. I do ask to keep it the same for now, recognizing that there's probably going to be some changes in the near future. I don't know how that's going to turn out. My client doesn't know how to turn out. What I do want to do is just protect this kid moving forward. And at this point, we're making allegations back and forth. We need some kind of third-party input on what the heck is going on right now, because Kyson deserves it. And that's kind of where we're at.
Ms. Baldwin?
Thank you. Parties come before the court because they can't come together and make a joint decision. And the request, once again, is to do nothing. Just send it for another investigation and kick the can down the road. But we aren't in a place where that's a reasonable decision. This child needs help now. He is in crisis now. When we look at the statements, well, there's no evidence. There is an entire threat assessment done by multiple third parties that then come together with all of that information and make recommendations. And mother says, don't just ignore that, put blinders on. Those are facts, not allegations. We have a whole threat assessment that says child shouldn't be around Landon at all. That child must remain in counseling with one of his counselors. And although my client is not saying my person or your person, the last counselor is the one that the school chose. And my client says, go with that person or go with the lady before that person. But don't just keep cycling him to yet a new person, because that's what mom wants to do, is to just cycle him to a new person who he doesn't have a relationship with and can't provide the treatment that he needs. Similarly, it's, well, this is allegations. Like, no, the school has detailed, thorough records that are horrific when you consider that these are the statements of a 9-year-old, that these are the actions of a 9-year-old. This is terrible. This kid is clearly being abused based on what he is then doing at school, and hence the threat assessment. Well, I don't know who's done this. The threat assessment's pretty clear about the underlying perpetrator. Similarly, when you look at the guardian ad litem report, it specifically states Ms. Cook does not deny the incident with Landon happened. So we have someone who's done something very inappropriate, and the allegation is, oh, well, it's Mr. Gavino's fault. But let's examine that for just a moment, because what my client says is, hey, I did take action. I offered to pay 100% of the counseling to keep the kid in counseling and to make sure that he got the treatment that the threat assessment said he needed and the counselor said he needed. But mom said no. Similarly, in my client's declaration, he said after he found out what had happened with the kids in Landon, he put strict controls on all the devices and then thought about it more and took the devices away. So he said, I'm not going to have any risk in my household, so I'm going to remove anything that could potentially be a risk. That's a substantial action taken in my client's household. Similarly, there's a single sleepover that they point to that was fully supervised by adults. And when you look at the text messages, they verify the adult was there the entire time. The 15-year-old was never watching them. And that's in the text messages that even she presents. The mother admits per the GAL report that her picker is broken and that she has a long history of domestic violence relationships and that she has a family system of domestic violence relationships. Yet no therapy has she done. Not one bit of evidence. And when you look at that letter, it's telling that the 2 dates that they put in there are for the intakes, but they don't have any dates for counseling sessions, so they can't put them in. So they would have put in dates if they existed. And I would argue they don't.
Speculation.
Mother makes claims about substance abuse. Again, we have an expert report that says no. Mother says, oh, I've been in contact with the school. Only when the school directly said, you have to do this, she's responding to their messages. And what has she done? She has moved the children closer to their abuser, basically in the same household as the abuser, and then says, I don't know why we're having, children's behavior disintegrate before our eyes. The threat assessment is very telling, and those are happening at the same time. So we can see these types of behaviors. The declaration by the maternal grandmother, no, we didn't respond to that. That's we have, of course, her mother is going to say whatever she needs to say to support her child. We focused on the facts of the case. And again, this was served extremely late on my office Wednesday afternoon, and we still turned around a response quickly, to your honor. The court previously issued a protection order against the children and Landon being together. That's, I think, why you see a gap in these types of behaviors. But when that expired, mother immediately began re-exposing the child to Landon and has continued to do so, including moving them to the same address. So where we are right now is a very clear system, a very clear threat assessment, very clear recommendations that per that threat assessment are must do. Otherwise, this child is in danger. So that is what we are asking for the court, is to take action. We're fine with an investigation. I think Keith Lawrence is best suited based on his professional history to engage in a further investigation. But simply saying, but let's wait 6 more months while Kyson's in crisis, that's not reasonable. We ask that your honor take action.
So based on the files and record, first off, in regard to the request for contempt, in regard to the introducing of romantic interest to the children until dating for 9 months, and in regard to the DV counseling, the court does not find, based on the record, that there was a violation. There are assumptions and allegations, but that is it. And there is child hearsay. This is a contempt matter that takes more than allegations. It is suspicious, no doubt, but that does not reach to the findings of contempt. On the matter of DV counseling, it is not clear if the counseling was to be of a certain type or by a certain person. The order says Madison Cook shall engage in domestic violence counseling with an appropriate provider skilled in that area. So again, given the importance of contempt, the court cannot find contempt on either issue. The court understands the objection to an email versus letterhead, but again, looking at the level required for contempt, the court cannot make that finding. Therefore, the motion is denied. And the petitioner shall pay $500 in attorney's fees to the respondent mother's counsel within 60 days of today's date. As to the request for relief, the court has significant concerns in regard to the child, Kyson in particular. That brings me to, first off, the court is going to appoint a guardian ad litem. And although Mr. Lawrence may have that level, Ms. Turnbull is most familiar with this case and the issues. So Ms. Turnbull, are you still there by chance?
Yes, Your Honor.
So I am going to go ahead and reappoint you. My question is, can you do a pretty quick turnaround?
I will make time.
Okay, so I will go ahead and reappoint Ms. Turnbull. It'll be under the same terms as the prior appointment. I don't know exactly what that is, but it should be under the same terms. And at this time, the court's going to be asking you, Ms. Turnbull, to look into these various issues that I'm going to rule on today. At this time, we do not know what's going on in regard to these children. And the court has significant concerns as to where the issue is remaining. And the parties may think, well, you're being too careful. Well, at this point, you need to be too careful. And that's what the court is going to be doing. So in regard to Landon, Jameson and Kyson shall have no contact with Landon. As to the counseling, this is difficult because the child, Kyson, has a relationship at this point, it sounds like, with Suzanne Snow, but the court doesn't know enough about Suzanne Snow to say whether or not she has that background or experience. So Ms. Turnbull, that's another issue I'd like you to look at. And if she does not, then we need to get a different counselor with the experience as to the ordering the mother to comply with the hearing order on June 7, 23. Again, there's a question about that, but the court does understand the concerns in regard to the issue as far as whether or not she's complied. The court does want the counselor on letterhead to provide more more information as far as what she's done, and a curriculum vitae, just to identify.
We're talking from Ms. Akinola from Core Health.
Correct.
Okay.
And that should be provided within 14 days. As to sole decision-making, the court is not going to order sole decision-making at this time. Again, decision-making is something that Ms. Turnbull can take a look at. As to the court adopting the proposed parenting plan of the father, again, the court denies that at this time until we have a report from Ms. Turnbull. What the court does not want to have, and what the court is hearing, is that Kyson is being left. We don't know, is this an adult? We don't know, is this another child? Something is going on. So Kyson is not to be left unsupervised by a parent with some third party, be it sleepovers, be it those, unless the parent is present for that visitation. I don't know if they have arranged daycare for something else, but at this point, the child is not to be left on, neither child should be left unsupervised with anyone else until we get to the bottom of what's going on.
Presentation, I think council, I can probably work through that order. Do we want a presentation date for late August when Judge Haan gets back? Counselor, what's your preference, Your Honor?
Fine to set, my preference would be to set a review on the 20th for Ms. Turnbull to provide information. By then we'll have the letter from the counselor on what has and has not happened. And we can review and do presentation at that same time.
Sounds appropriate.
And then the court, is the court going to rule on the request to change the child's school, given the mother's allegations that it's the child being abused by schoolmates?
Well,
So-
no, we don't know who's abusing the child. That's the bad part.
Yeah, that's, thank you for bringing that up. Ms. Turnbull, I would just ask you to look at that issue as well in regard to what school. Again, we don't know. That's where it really takes somebody who has that background and experience. And if he discloses the abuse, then obviously there's another level of people that can look at this and make that evaluation of who it might be that is harming the child.
Understood. Thank you.
All right, so August 20th for review and presentation.
Correct.
Yes, Your Honor. Sorry, I was just muted. I'm here.
Very good.
I apologize to put you last on the docket. Been a long docket. Just a minute.
And Beth Fellows, the GAL, is present as well, Your Honor.
Go ahead.
Thank you, Your Honor. Court's well aware of this case. I do represent Melissa Young Meter here on my client's motion for contempt. This is a case that you initially heard argument from a couple of weeks ago prior to the request by Mr. Stevens to set the matter over so the court could review his responsive declaration that was filed around that same time. I do think this is relatively straightforward. This is one where the court has been explicitly clear with the father that his contacts with the kids are not appropriate. His actions have been very problematic over time, and the impact on the kids has certainly had an effect. My existing plan was entered just after the first of the year, essentially cutting off contact with him. No contact with either child. That would be Nathan, who's 17, Liam, who's now 14. Yeah, who just turned 14. That was been in place. The court at that time also issued significant findings for treatment and steps he needed to take to kind of cure a lot of his emotional issues and put him in a place where he could be there for the kids. Again, we're now going on about 6 months since entry of that order, and we've been provided with absolutely nothing related to those evaluations, those treatment options, the counseling, and so forth. Unfortunately, we're back. This is a case where, again, to Mr. Roberts' credit, we attempted to try to resolve the issue. We were confident that it would, and within a couple of weeks, we were right back to where we are, unfortunately, now, thus prompting this contempt motion. Number one is the communications, and historically, this was part of Ms. Fellows' report and findings that Mr. Stevens is very inclined as it pertains to social media. This guy works in the computer industry. He's an expert in that field. Yet in past hearings, he would say, well, I don't know how to work this Our Family Wizard app. And I now most recently he's saying, well, I accidentally included the children or one of the children, Nathan, in these various social media posts. Again, it flies in the face of reason. I mean, it's completely bewildering to me that we continue to have these ongoing issues. He continues to fall on the sword that's put him in this place to begin with. Specifically, as it relates to the contempt, what has he been doing? Well, he's inviting Nathan into these various online chat communities, these social media communities, in which he is pretty much the host of those. One of them is a Facebook group called Coffee with Jesus. This was one that was commenced after we were in court, after the first year, after the court said you're not to have any contact with the kids, pending all these evaluations and treatments. he conveniently starts this forum and somehow invites Nathan into the group. And as the court's aware, and forgive me, I'm not a social media guy, but nonetheless, I think there's one of two ways from what I do understand that somebody could be part of that community. Number one, they're invited in. They essentially get an invitation from the host that says, hey, join my community. Here's what I'm doing. Or the other way would be randomly that Nathan just somehow knows about or is communicated from dad, and again, somehow invited into that, or somehow by some magic design just happens to stumble across it, which seems highly unlikely. The concern on this, and it goes beyond just, seeing what dad is posting. There are very specific messages aimed at Nathan and Liam. And again, if you look at this, we provided you a sampling of those. You've got one, and I don't think this is the coffee with Jesus. I think this is a different one where this is being sent to Nathan. It's some kind of a cartoon that says, Dad, can I have my son this weekend? And then the mom sitting there on her phone responds, let me ask his stepdaddy. Now, again, Mr. Stevens has had significant issue with my client's current husband. That has been a source of, I don't even know how to quantify that, frustration for Mr. Stevens from the onset of the relationship. And now he's communicating with at least Nathan in a very derogatory, unnecessary manner. Again, this is aimed directly at the child. There's another, and I think it's even more specifically, which I don't know why you would post this unless this is going directly to the receiver, which would be the boys. I miss you more than anything in this world, Nathan and Liam. My boys, you are always in my heart. So again, although that would be great in proper context, it kind of flies in the face of reason to suggest, oh, I had no idea that the kids were able to access these messages when you're specifically addressing them to your children. So again, is that willful and intentional? I certainly think it is. Is it in violation of the order? I think quite clearly it is. I think when you're tagging individuals, inviting them to your group, when you're playing these types of games, he knows what he's doing. Again, that's his history. That's what he does. He looks for little wormholes to exploit orders. He looks for ways to manipulate his boys to the people that he views have somehow done him wrong, and that would certainly be my client and her new husband. And this is just the ongoing gamesmanship he plays. We have attached for your review communication I had with Mr. Roberts, and again, to his credit, I certainly appreciate the response he gave, trying to get out in front of this, which does state, and this was cleared back in May. I addressed it to Mr. Roberts. Apparently, your client is tagging the older child with these social media posts, reminding him of the order. Please ask that he stop. Mr. Roberts, as he typically does, in quick response, says sorry for the delay, even though it was only a couple of days. Talked to his client, and it was a quote accidental tag. We now know that just simply isn't accurate. That simply isn't truthful, and it simply isn't honest. So we are asking for a contempt. We are asking for the fees as we've requested, as well as a civil penalty, because this is unfortunately plagued this case since we were first before you last fall. And where do we go from here? I don't know. I mean, he won't do what he's supposed to. He's made no efforts to pay attorney's fees that were ordered in the past. He's made zero efforts to comply with court orders related to counseling and treatment options. He hasn't gotten the assessments. He only wants to do what he wants to do when he wants to do it. I think this is a case where jail time, and I'm not asking for it specifically today, but I do think a strong message needs to be sent to him that if this continues, if he continues to try to manipulate and bully, it's going to be dealt with harshly and swiftly. That's what we're asking. And I think the only way to really resonate with him would be some kind of threat of jail time, so that he knocks this nonsense off and allows these boys to be boys and in a healthy environment.
Mr. Roberts.
Thank you, Judge. So I think there's a lack of clarity in what Mother put forward in her declaration. My client goes through each post and explains what it actually is and how we got to where we are. Mr. Zandy mentioned the cartoon being sent to the first item, the cartoon being sent to Nathan. I do not believe that's clear. I don't believe it's accurate. I also don't believe that's substantiated by the pleadings. What it looks like, even from what she filed, was it states Mark's post, meaning it's a Facebook post. It was a post to his regular Facebook profile. It is not dated. So my client went to the lengths to show the court that Nathan has two accounts. The initial one was blocked. There was the second one. I didn't look at how many, and he's not screenshot how many Facebook friends he has, but the court is likely aware that there are hundreds of friends, and you block the one that you think exists. And then there was the second profile with the cartoon face, which has very little information even from the screenshot here. That must have been the reason why he was able to see it. There was no response from Mother as to how this information was even obtained, which is concerning. And then my client shows a screenshot that he has blocked both of those accounts at this point. With respect to the cartoon, it wasn't directed at Nathan. It wasn't sent to Nathan. It was a post, and I have a lot of issues with the judgment of various people who use social media for any purposes, let alone anything with respect to parenting children. But this is a post that looks like it was to his regular profile. Nobody's tagged. And that's the end of it. Anything that predated my email to Mr. Zandy, I think it can easily go in the bucket of it was an honest mistake. I don't see anything dated post May 17th in her pleadings, and there was no reply that was filed. So we're devoid of any information in the record to rebut anything that my clients put forward. With respect to the second post of I miss you more, speaking allegedly to the children, I trust the court has seen lots of messages that are posted on social media that are just out there, and it's a prayer, or it's a manifestation, or it's just speaking into the ether when they know no one can listen because of circumstances. Again, no one was tagged. Again, this was not dated in terms of a time. So we are once again in a situation that the court can't decipher, and I believe my client addresses it in his declaration about the timelines of those instances predating May 17th. There were 3 other posts that Mother articulated in her profile. The Coffee with Jesus is a public page. I don't know how familiar the court is with this, but when you have a public page, and I believe my client indicated this in his declaration, you invite your whole friends list, and no one's going through and I'm inviting 600 individual people. There's just an invitation, whether he found it on his own, the record does not show, but even if he invited everybody, it was a situation where his friends list that was on there. As far as I can tell, and as far as the record shows, I believe this page has been around for a while, so it even predated the court order. Without anything in the record, we can't make any conclusions about that. If the kid has access to a public page, the kid has access to a public page. If he was invited previously to the order, then he was invited previously to the order. If he was invited in the slew of 1,000 friends being invited, it's easily an honest mistake that nothing post May 17th has been articulated. Again, in the third post with the plant and the coins, no, there's no tag whatsoever. So specifically are targeting the children. We're 3 for 3. There's no tag. The fourth post has a child kneeling in a post. Once again, there's no evidence that any child was tagged. And in the fifth and final was again on the Coffee with Jesus page. You can see that the word Nate exists and it's not tagged because there is a bold associated with any tag. If the court's familiar with Facebook, bold is how names are tagged. There are other indications in even what Mother provided where the tags are the bold. Mark Stevens with 99 friends, and it's bold because that's the tag. Nate's specifically not tagged in that post. We can infer that he witnessed that post through the second account based on what the record establishes, but there was no tag, so the court, I think, can make sense of what happened there. I know Mr. Zandy's saying this is a straightforward issue, but there's simply not been a single post articulated that shows a date and that shows that Nathan was specifically tagged, and that's really the thrust of the issue. People make mistakes on social media all the time. I do not believe the record has established that Mr. Stevens is an expert in social media, etc. He had a marketing business that is not computer programming or anything along those lines. So I think assuming that he has a very intimate knowledge of exactly how these things work is inaccurate, and the burden's on Mother to show that the children were tagged, number one, and the dates in question show that this was after he'd been made aware that there was tag involved or an awareness involved, and that after being made aware of it, he took a specific action. The record simply doesn't have that. So I would ask that the court simply dismiss the motion for contempt with respect to attorney's fees. My client's declarations made it clear that he doesn't have the money. I am helping him with a divorce. He's going through a very difficult divorce. He owes my office thousands of dollars at this point. There's significant issues and problems with the financial picture. He simply doesn't have it. But I think the court can't put the issue to rest. The record does not reflect that post May 17th there was anything that even remotely targeted the children. Thank you.
And again, the order was in place on March 17th. I think we all agree that this Coffee with Jesus was developed about 2 months after that, which would put you in that May. So Coffee with Jesus didn't even exist in March. That was after the fact, and that doesn't seem to be disputed. And if you look at the last message we have, it says the psalmist of the Lord, Mark Anthony, and you've got hashtag Nate Stevens, hashtag Promise Keeper, hashtag Coffee Hollet. So it does appear by all intents and purposes that the child was targeted. So I'm not sure where that originates, as opposed to just, well, you don't have the smoking gun per se when we have about 5 of them. And again, I don't know. I'm not on social media. I find it hard to believe that I would send out some kind into the aura, as Mr. Roberts describes, some kind of a message to my kids, knowing I have no contact with them. Again, that flies in the face of the reason, and that is somewhat disingenuous considering he says, well, you can't really prove it, and I wasn't really gearing anything towards the kids when he has a direct message to them. And again, knowing And here's the thing, if we're in court and I've been admonished the way that Mr. Stevens has, and I know that I have to do certain things to have communications with my kids, as opposed to taking a back route and doing this ambivalently on social media, I'm going to do what's expected of me so that I can get back into my kids' lives without having to manipulate orders and find wormholes. He's done none of that. And the fact that he's posting a message, and I don't know if this is on his Facebook or whatever it is, can I have my son this weekend? And then mom says, let me ask his stepdaddy, and then claim, oh, inadvertently, I've been sending that to everyone out there. Given he's going through a nasty divorce with his current wife, given his history in Clark County through the divorce with my client, given where we stand today on the modification that he's done nothing, I'm not sure a logical person would post that on social media, let alone send it to the kid that I can't have contact to, or know that there's a chance my child might have contact to that. Again, this is really similar to the issues we've unfortunately had with Mr. Stevens, which is not surprising to my client. This is just who he is. He's doing this on purpose. It's in violation of the order. It needs to stop.
Your Honor, what I would just respond to that is, we're not here to cast judgment on people's decisions. We're here to answer a specific legal question. I don't like my clients using social media anyway. I think it's a bad idea, and I would personally admonish it. But that doesn't mean they're in contempt. I don't see the record showing there was a tag. I understand Stevens' name is there. I don't see it being tagged. If that is wrong, then there can be a response in which there was not filed of showing there was a tag involved. It's a public page that I don't dispute had access to. I'm unaware of that when that page was created. Once again, I mean, we had a situation where when I responded to Mr. Zandy saying my client inadvertently tagged the child, obviously I am not inside my client's mind. I'm relaying what I'm aware of and or at least what I can represent and what my client's informed me of. My understanding was, as of that date, now the clock runs. Hey, if there was a mistake, then we're moving forward, and anything beyond that is certainly going to be something that's brought back to court. I'm unaware of any post that's been made since that date. It's not articulated in the motion, and I'm not trying to split hairs. I'm looking at the motion, and it looks like there are these non-tag posts from dates unknown. I don't see that he's tagged, and anyway, I realize I'm repeating myself here, but I'm looking at dates here, and I don't even think Mr. Zandy, even in his response here, has articulated which posts were pre and post May 17th. I think the court is likely going to consider that May 17th has some significance, and I'm not even sure how to respond to anything beyond that, other than what we've done in our declaration, articulating the tag and the lack thereof, and the chronology that we've already described. My client did specify on page 2 of his declaration that the May 7th shared post from Coffee with Jesus was May 7th, and that was before he was made aware. And
well, and I can say as an officer of the court, a lot of the issues continue to permeate. So I'm not going to get into that because it's not in a declaration, but he continues to do things and communicate with my client through the child that is highly inappropriate, and I will discuss that with Mr. Roberts this afternoon if we can find time for a quick phone call. But the date of the order was March 17th. So anything that happened after that, he was aware of the order. He was on Zoom. It's not May 17th. It's March 17th that is prevailing here.
And you said 2 months later?
Correct. Yeah, Coffee with Jesus. I think everybody stipulates that was created after March 17th.
I'm unaware. I can't represent that. I do know in my client's declaration, he mentioned May 7th post where he used the everyone tag, which had his whole friends list. So thinking he blocked Nate's first account, it captured the second account, which he understood to be unused. That was the time period right before the made aware of it, mea culpa, blocked the account. That's all the information I have.
Okay. So I did review the files and record, and I've made it very clear that the father is not to have contact. And so based on the files and record, the court does rule as follows. 1, the court does find the respondent in contempt in an intentional and malicious violation of orders of the court for the following. He has failed to comply with the parenting plan and having no contact with the children. Mr. Stevens has willfully and intentionally had the contact in violation of the court order by the Facebook contact. The court does not find or believe that there was any mistake. The continued contact after supposedly making a mistake makes it very clear. Mr. Stevens can purge the contempt by paying $250 in civil penalty within 14 days of today's date and paying $1,500 in attorney's fees for the necessity of having to bring this motion, plus the cost of service, and comply with the parenting plan and have no contact with the children. If that does not occur, then this matter needs to be brought back before the court, and the court will consider jail time of not less than 3 days for the blatant violations of the court's orders. It doesn't seem that the father wants to respect that the orders have been made. And so if he continues with this, the consequences will continue to go up, bottom line.
Presentation next week.
Yeah, let's go ahead and put it on. That docket's closed, but I'll put it on July 30th.
With respect to purging, it was 250 with the both payments within 14 days, or did I articulate this?
Yes, let me clarify that. So $250 in civil penalty within 14 days of today's date, and then the $1,500 in attorney's fees, I'll go ahead and make to 60 days for the necessity of having to bring this motion. And then the cost of service, that same time frame.
Very well. Thank you.
Judge, have a good day.
You too.
Thank you, Your Honor.
Thank you.